distinguished guests, special invitees, panelists and participants joining us here at the Shangri-La Colombo and of course online. A very warm welcome to this momentous occasion as we partake in the 4th International Chamber of Commerce, also known as the ICC Sri Lanka Arbitration and Mediation Hybrid Conference 2025, organized by the ICC Sri Lanka. A little bit of context, ladies and gentlemen. The ICC Sri Lanka Arbitration and Mediation Hearing Center under the ICC rules offer a neutral, binding and flexible process to resolve commercial disputes efficiently. The ICC, for the past century, has been the global leader in trade and investment facilitation, representing 45 million companies across 170 countries, supporting over 1 billion private sector workers. It is the sole authority of ATA Carnet in Sri Lanka and streamlined international trade. Established alongside the ICC International Court of Arbitration, the world's most trusted dispute resolution mechanism. As a Sri Lankan chapter of the ICC, ICC Sri Lanka stands out as the only chamber with representation in the United Nations, WTO, UNCTAD, and the UNICEF. ICC Sri Lanka also bridges international chambers with local impact by embedding global standards to domestic processes, ensuring credibility, cost-effectiveness, and integrity, with a collective aim of revolutionizing alternate dispute resolution in Sri Lanka by positioning Sri Lanka as a regional hub for dispute resolution. And so, ladies and gentlemen, as we set the tone for today's proceedings, let us now turn our focus to the heart of why we are all gathered here today. Today's theme, ladies and gentlemen, is to explore the evolving role of arbitration and mediation in shaping the future of dispute resolution, both locally and internationally. And for that cause, we have a rich lineup of distinguished speakers, industry experts, and practitioners from across the world. And so I encourage you to please take this opportunity to exchange perspectives, foster connections, and carry forward new knowledge and practical tools to your own practice and beyond. To formally commence, I'd now like to invite an individual who is the driving force behind the Sri Lankan chapter of the ICC. An accomplished scholar, legal professional, and corporate leader who has made his mark both globally and locally. Ladies and gentlemen, please join me in welcoming on stage the chairman of ICC Sri Lanka, Mr. Shanil Fernando.
Good morning, Your Lordship, distinguished speakers, panelists from Singapore, India, Malaysia, and Sri Lanka who are present here. They flew in within the last 2 days. Colleagues and delegates joining us from around the world via Zoom link. It is my privilege to welcome you to this landmark conference on ADR. This is the 4th time that we are having this. We have had 3 times before. This is jointly hosted by ICC Sri Lanka and the ICC Sri Lanka Arbitration and Mediation Hearing Center. We have over 250 people who have registered, which includes arbitrators, mediators, legal professionals, academics, and policymakers. I had the privilege of starting my arbitration journey at the chambers of Egakure, a well-known arbitration lawyer those days, who brought ICC to Sri Lanka 70 years ago. So ICC in Sri Lanka was set up 70 years ago, and he also set up the National Arbitration Center. The Colombo International Arbitration Center was established in 2010 by ICC Sri Lanka and was reactivated recently and renamed as the ICC Sri Lanka Arbitration and Mediation Hearing Center, to be a hearing center for ICC arbitration rules and ICC mediation rules. With the guidance from Mr. Tejas Chauhan, ICC Regional Director based in Singapore, and with the support from ICC Paris, Mr. Chauhan is present here. Yesterday, Mr. Tejas Chauhan declared open the ICC Sri Lanka arbitration hearing center at our own premises in Colombo 3. This transformation deepens our global integration and reflects our expanded role in both arbitration and mediation network. Aligned with the ICC international strategy, following the ICC centers in Paris, Singapore, Hong Kong, Abu Dhabi, and Sao Paulo, our aim is to make Sri Lanka Center a regional hub for ICC arbitration and mediation in the SAARC region. This will strengthen investor confidence, attract foreign investment, enhance legal infrastructure in Sri Lanka, and position Sri Lanka as a trusted venue for global dispute resolution. This center is chaired by me and governed by a board of top industry leaders, including Ms. Sashani Javardhana, Chairman of the Akin Spence Group, Johnny Fernando, Captain Nalin Piris, Indika Rajapaksa, Buddha Priya Ramanayaka, Hemakumara Gunasekara, and Srinath Disoisa. The center is supported by an advisory council, a foreign advisory council, led by Dato Jude Benny of Singapore, a very well-renowned shipping arbitrator and founder of the Dato Jude Benny law firm, one of the largest law firms in Singapore, who was instrumental in setting up arbitration centers, I believe in Dubai and and even in Singapore, the mediation center, I believe, and he will speak about it. He's also already here. He flew in last night. He was also my arbitrator a few years ago for an ICC arbitration held in Colombo, where the case management was done by ICC Paris. Now the case management is now, I believe, done in Singapore. Yes. The center has local advisory council of 58 top corporate lawyers and some of the government departments' legal heads nominated by their respective institutions. So most of the listed companies have nominated their heads of legal to this local advisory council. That's how we have 58 lawyers. You are welcome to join the advisory council and support us, because we plan to have interaction with you on a monthly basis. I think in June we had a mediation hybrid seminar as well. I'm pleased to announce the new education initiatives undertaken in the future by ICC Sri Lanka Arbitration Center. We are planning to start the diploma in ICC arbitration rules for advanced training in international dispute resolution in October. Certificate in mediation, ICC mediation rules for students and early career professionals to build an ADR foundation for their career. Both programs will link Sri Lankan professionals to the global opportunities as arbitrators or mediators. We are looking on arbitration, obtaining international accreditation and membership from international ADR education centers for these diploma holders. We will give 50% waiver to the visiting card holders or the institutions of the course on the course of this for visiting cards draw today. Please put your visiting card at the bowl at the entrance. I extend my gratitude to both foreign and local advisory councils of the ICC Sri Lanka Hearing Center and the ICC Sri Lanka Secretariat for their dedicated efforts to make their event a success. Over the course of the day, we will discuss the future of ADR, dispute resolution, shaped by digital transformation in ADR. I thank Justice Kodagoda, who is present here, and Justice Nawaz, who will be coming in the afternoon, and our local and foreign panelists for their support due to the time constraints, many colleagues could not be included as speakers this year. There were a lot of interest. They wanted to come as speakers and panelists. But next year, we plan a 3-day conference with a broader participation. Some of our international speakers and panelists are joining via Zoom, and this event is streamed on the ICC Sri Lanka Facebook page for ICC members across 170 countries. Thank you for your participation at this conference. God bless you.
Thank you very much, Mr. Fernando. Ladies and gentlemen, to kickstart the series of today's insightful perspectives, we are deeply honored to welcome world-renowned arbitrator and mediator and founder of Joseph Tan Jude Benny, LLP Singapore, Mr. Dato Jude Benny, who will present on the topic, Why Arbitrate?
Good morning, ladies and gentlemen. It's a great privilege and honor for me to be speaking to you today. I'm told I have 15 minutes. I'm not sure how much I can say, but I'll try and capture it all if I can. Firstly, the topic I'm talking about today is why arbitrate? And I don't have any slides or anything because I have actually written an article called Why Arbitrate? For the center. So it's on their website. And so one sure way to sort of drive a bit of traffic to the website would be for you to go and read that article if I don't make any sense to you this morning. All right, so why arbitrate? But even before I sort of talk about why one would choose to arbitrate, I'd like to talk a bit about arbitration centers. There is a wish in many jurisdictions, from Malaysia, Hong Kong, even Myanmar, Bangkok, for them to be arbitration hubs. But wishing to be an arbitration hub is not going to make it happen for one very simple reason. Because an arbitration, or the right to arbitrate, is born out of contract. So in 2004, I was very honored when I was sitting on the board of the Singapore Maritime Foundation to be charged with the responsibility of trying to set up the Singapore Chamber of Maritime Arbitration, which is now up and running. So we're talking of 20 years, right? Now consider this statistic. In last year, the London, I'm going to sort of speak about maritime arbitrations and use that as an example. The LMAA, London Maritime Arbitration Association, had close to 3,000 references, maybe 2,000 or so, of which actually went into hearings. Next on the list of maritime arbitrations comes Singapore. So remember the first number? Close to 3,000. It was about 2,700, I think. Next comes Singapore, 77. So what does that tell you? 20 years, and we have 77 cases, and London is still holding a significant lead, not only over Singapore, but over the rest of the world. Why is this? Firstly, of course, there's the weight of history that backs London, because Lloyd's of London, marine insurance, ship financing, all of this basically grew out of London. So it tends to gravitate towards London. But in order for any center to take off, you need to have the clause written into the contract. So that is the key. That is the key to everything. Because if it's not written into the contract, you don't have the right to arbitrate. You have to go to court. So it needs to be written in. And what needs to be written in? So if you want Sri Lanka to be written in, you've got to convince people to write it into their contract. And that, believe me, is not an easy task at all. 20 years on, we've got 77 cases in Singapore. So, to create any kind of groundswell, you need to have a significant marketing arm that is going to convince people that they should write in the arbitration clause into their contracts. Because without it, you don't have the right to arbitrate. So that is actually a marketing effort. So in the Singapore Chamber of Maritime Arbitration, which is not administered arbitration, unlike the ICC, which is administered arbitration, the SCMA still has an office. And what does it do? It has a significant budget marketing SCMA, marketing Singapore arbitration. So in the same way, in order to get Sri Lanka to become an arbitration center of choice, you need to have significant marketing convincing people to write it into their contracts. You start, of course, domestically. If your own companies don't write it in, then you've got a problem. So you start by convincing people domestically to write in the contract, and then you sell the value proposition to people regionally to use this Sri Lanka and this center as the place for their cases to be adjudicated. So that's a sort of context of the challenge that we face in terms of trying to get a momentum going in the arbitration context. Now, then I come to the sort of subject matter of what I'm supposed to be speaking about, which is why arbitrate. Well, I can give you I'm only going to give you two main reasons. The first is confidentiality. You would arbitrate because there is confidentiality. If you go to court, of course, reporters are there, everything gets blasted in the newspaper, that is the nature of the animal. But in arbitrations are confidential. So businessmen prefer arbitrations because they rather wash their dirty linen in private. Okay? So whatever happens stays in the arbitration room. There are you don't report it, nobody knows what has happened. Of course, the award is there, it's binding, it can be enforced, and we'll be hearing about enforcement later, but confidentiality is probably the biggest reason why people choose to arbitrate. The second is subject matter expertise. And this is very, very critical. Because businessmen, whether they are in construction or in shipping, they want an arbitrator who has the subject matter expertise and the ability his uptake into the case will be very, very short because he knows the subject matter, which, and in many instances, not that judges are incapable of doing it, of course they are, but they do not do the same case over and over and over again. So if you get a construction arbitrator, the uptake is phenomenal because he'll dive straight into the case, and what would otherwise be perhaps a week-long hearing can potentially be cut down to 2 or 3 days because he's so familiar with the issues. Likewise in shipping. If you get an arbitrator who has the specialist knowledge, he will be able to deal with the case very expeditiously. And so the subject matter expertise is a key reason as to why you want arbitrations. So you don't really want the throw of the dice, in terms of going to court, but you can be assured that if you go into an arbitration and where the parties pick the arbitrator, because you have a situation where 3 arbitrators, the party nominated arbitrators from each side, and then the 2 arbitrators pick a chair. And of course, if I'm nominated and I've got somebody else from the shipping context, we're not about to pick somebody, who's a doctor, right? Because you would want that if you have some medical related type of case. But so we would pick people who are able to deal with the subject matter very, very quickly, very promptly, and with the specialist knowledge that they have in that area. So why arbitrate? 2 key points: confidentiality, subject matter expertise. The third, which I think is equally important, is informality. I think the informal setting of an arbitration is very appealing to parties. It's not as daunting as going to court, right? So, but the personality of the arbitrator is very important because it comes to bear in the way that the arbitration is conducted. So the personality, so you have to pick your arbitrator very carefully, because an arbitration is only as good as the arbitrator who's doing it, you know. So you've got to pick somebody who the parties have got confidence in, because there's nothing worse than having an outcome or an award at the end of the day where the parties are just going to be so upset about everything that has happened. So you would want an arbitrator whose personality is appealing to the parties such that they feel comfortable. Of course, they have counsel, and all of the arguments will be put forward. But you want, when I sit as an arbitrator, I try very, very hard not to make it a replica of a court hearing, because that's not what the parties signed up for. They signed up for an arbitration. They want the informality, and they want to be treated in a different way. So the entire setting and the mood is very different. And I think those are very, very appealing points. So it's a big words here that says time's up. So it means thank you very much, and there'll be a panel discussion. Maybe I can say a bit more then. Thank you.
Thank you very much, Mr. Benny. I'd like to kindly ask you to please come back up on stage to receive a small token of thanks. To do the honors, may I kindly invite the presentation party, the members of the ICC Sri Lanka board, to please present a token of appreciation to Mr. Dato Jude Benny. Thank you, gentlemen. Next up, we are honored to have with us the next speaker for today. Ladies and gentlemen, please welcome the ICC Regional Director for South Asia Arbitration and Alternate Dispute Resolution Services, Mr. Tejas Chauhan.
Good morning, ladies and gentlemen. Thank you so much for being here on this early morning. Members of the judiciary, members of the bar, distinguished colleagues from law firms, foreign practitioners. I'm the regional director of the ICC, and I will be speaking, taking a cue from Dato Jude Benny, who mentioned why arbitrate. And assuming that now you're all convinced that you need to arbitrate, and there are, of course, benefits of arbitration, what is the value proposition of institutional arbitration? And without any surprise, I will speak about one particular institution, which is the ICC. And hopefully, I will be able to answer questions around popular perceptions, misconceptions and perceptions of the ICC. So over the last 2 days during my meetings, I've heard many of you say that the ICC is a great institution, but for an ICC arbitration, we need to go to Paris. Or that the ICC is more expensive, and that is why we choose institutions in Singapore, Hong Kong, London, so on and so forth. And to do this, I'll use some slides, and hopefully I'll be able to take some questions. I have 9 minutes and 27 seconds as of now. Now, ICC is not just an arbitral institution. The ICC, of course, has the arbitration rules, but the ICC also has mediation rules which are very common. I know that we have a panel on ICC arbitration and mediation. That is something that we see parties using. You can also do so using the ICC rules, where you can get into an ICC mediation, get into an ICC arbitration, and the costs are adjusted. There is also the ICC Center for Area, which administers proceedings under dispute boards, something which is very common in construction arbitrations. We also have expert rules. We also have doctex, which are documentary credits, often used in trade finance. For the purposes of my slide today, I'm going to focus on arbitration. And what I want to do is that I want you to keep one thing in mind, that every arbitral institution, whether it is the London Court of International Arbitration, whether it's the Singapore International Arbitration Center, whether it's the Sri Lankan Arbitration Center, they're all doing the same thing, which is administration of your disputes. So tomorrow, if you have a dispute and you want an institution to ensure that the arbitration runs on time, there are costs which are capped. It is the responsibility of the institution to do so. Every institution more or less has the same features. So ICC also has consolidation provisions, fast track provisions, joinder provisions. Other institutions also have that. What I want to highlight is something that makes the ICC stand out, which is the true value proposition. Because when I'm speaking with a lot of in-house counsels, and when you draft your contracts, you should know why you're choosing a particular institution, because it is insurance. You're not thinking of falling sick tomorrow, but when you buy insurance, you want to buy the best insurance. You want an international brand, you want reimbursement, you want a 24/7 helpline. And that is the same thing that you should keep in mind when choosing an institution. Now, we use the word court, and it is very funny because the whole idea is to get you out of court. But the ICC, International Court of Arbitration, is actually not a court per se. It is a body comprising of arbitration practitioners from around the world. We have court members from Sri Lanka. We currently have Dinal Phillips, who sits on the ICC court. We've had Dr. Harsha Cabral, who sat on the ICC court before. And what does the court do? The court is empowered to take decisions under the ICC rules as an independent body. For example, confirmation of arbitrators, deciding on challenge to an arbitrator. And why the court does this is because these are all renowned arbitration practitioners from around the world. The court meets regularly. There are sessions that take place almost every week. And in the work that the court does, the court is assisted by the case management team, the secretariat of the ICC, of which I'm a part. Now, one popular perception of the ICC is that the ICC is only in Paris. Yes, the ICC was founded in Paris 100 years ago, but the ICC is now the only institution in the world which is not tied to a geography, which is not funded by a government, and which has no vested interest in promoting a particular seat of arbitration. And that is why it is the International Court of Arbitration of the International Chamber of Commerce. It is not linked to a seat. So we have a case management office in New York. We have a case management office in Brazil, in Sao Paulo. We have a case management team in Paris, which is where we were founded. We have a case management team in Abu Dhabi. We have a case management team in Hong Kong. And we have a case management team in Singapore, in Maxwell Chambers, where SIAC is on the 3rd floor and the ICC is on 2nd floor. So if you're choosing Singapore and you think that automatically means the Singapore International Arbitration Center, it does not. You can have an SIAC arbitration in Paris, just as you can have an ICC arbitration in Singapore. But I will also take the liberty to say that you can have an ICC arbitration in Sri Lanka, using Sri Lankan arbitrators, using Sri Lankan law as the governing law. Now, very quickly, because I have 5 minutes, why ICC arbitration? Truly international institution, and that is not just with the case management teams that we have. It is also reflected in the cases, in the numbers that we see. So it is not a regional institution. Parties come from all over, including Sri Lanka. In 2024, the ICC had more than 2,300 parties that came from more than 100 countries. Arbitrations were seated all around the world, including in Sri Lanka, in Colombo. And in terms of amounts in dispute, another popular perception of the ICC is that it is only good for the big billion-dollar disputes and not for the small value disputes. Yes, the ICC has a lot of big million-dollar disputes, but 30% of ICC's caseload is within the $1 to $5 million range. 30% of ICC's caseload is purely domestic. So 2 Sri Lankan parties choosing ICC arbitration. If I have to just pick one value proposition and something that I want you to remember. It is the scrutiny of awards that the ICC does. Now, scrutiny of awards is important and it's directly related to cost, because when you have an arbitration, what you want in the end is a good final enforceable award. If you don't have that, then you'll be making an application to the court to set aside an award, which would lead to more time and costs. And this is where the ICC court comes in. Under the ICC rules, no award can be notified to the parties unless and until it has been reviewed and approved by the ICC court. So it's a 3-level scrutiny process. The first level of review is done by the case management team, which is Singapore, Hong Kong, New York, Sao Paulo, Abu Dhabi. It then goes to the management of the Secretariat, which is the Secretary General, the Deputy Secretary General, managing councils. And then it leaves the Secretariat to go to the ICC court, which is 190 members that I spoke about. And 3 things happen here. Either the ICC approves the award as it is, which is the green box, that the ICC has no changes or no recommendations. Or the ICC approves the award in principle, which is the yellow box with comments. And the red box, which is concerning, which is 10% of the cases almost every year, where the ICC does not approve the award and sends it back to the tribunal to redraft. And if you had any one of those cases and there was no ICC, what it would have meant was that these awards were so bad that they would have been set aside by the courts. And no institution does scrutiny like this. This is something which is very unique to the ICC. Even ChatGPT will tell you this. Now, another question that comes here is that, is the ICC interfering with the arbitral tribunal's discretion of decision making? No, the ICC is not telling the tribunal, you got it wrong and please change your decision. What we are telling them is that we're making changes as to form, but drawing their attention to matters of substance. For example, res judicata. Have you considered the principles of res judicata before applying why they are not met in the case? Calculation errors. How have you awarded interest? How did you reach the magical number of 12%? Is it simple? Is it compounded? What is the start date of the interest? What is the end date of the interest? These are common issues that we identify. Number 3 is that yes, Tejas, ICC is great, but it is very expensive. And this is something that you would have heard. And I'm going to ask you one question right now. How many of you work at law firms? How many of you are external lawyers in the room? Please raise your hands. Law firm lawyers? Okay, Samir, I see one. Only one person working at a law firm? Probably more. Just raise your hand. No questions. I just want to know how many lawyers am I talking to. No questions. Okay, now I see some more. Please keep your hands raised. How many of you advertise yourself as the cheapest lawyers in Colombo? Nobody wants to say that we are the cheapest law firm. Nobody wants to say we're the cheapest institution. Cost is a result of service. Cost is associated with service. Is the ICC more expensive than your local Sri Lankan arbitral institution? Yes. Is the ICC more expensive than the Singapore Center or the London Center? Absolutely not. And that is something that you can predict using the cost calculator. Go to Google, use the ICC cost calculator, put in your amount in dispute, and compare the cost. ICC will give you a total, SIEC will give you a minimum, average, maximum. Look at the maximum where they fix the fees and compare those costs. Another very interesting stat is that when we speak about stats and the cost associated in an arbitration, this was a study that was done to analyze more than 300 arbitrations and costs. In an arbitration, if you're spending $100, $83 is actually legal fees that goes to the lawyers, which starts from the start to the finish, and nothing against lawyers, I was also a lawyer at one point. 15% of $15 is the fees of the arbitrators that is going to be capped. And this is capped under the institutional rules of the ICC. And only $2 or 2% is the fees of the institution. So this whole argument about this institution is cheaper and that institution is more expensive, you're talking about $2. And then for the cost that you're paying the institution, the ICC is unique in the sense that the ICC has a provision where if your arbitrators are delayed, and I know this is a problem in Sri Lanka, as is the problem in many other countries, including India where I come from, if the arbitrators are delayed, the ICC will reduce their fees and give it back to the parties. Only the ICC does this. It is also something where the fees of the ICC can also be reduced because this is something that is codified and that is where the ICC court comes in. So this is something which I would request that you keep in mind. Last slide, because I know time's up. If you do decide to choose ICC arbitration, please stick to the standard clause. Do not be very creative with drafting your dispute resolution clauses. Do not mention ICC arbitration SIAC. SIAC is an institution, it is not a hearing center. If you do decide to use the ICC, this is the clause that we advise. Mention the place of arbitration, which is the seat of arbitration, not the venue. Venue is something that you can decide later. Venue is also something that you should decide later because depends on the dispute, depends on when you have a dispute. Language and the number of arbitrators, if you decide to have 3 arbitrators, the cost is going to increase. That was my time, ladies and gentlemen. I can take questions later. Thank you so much.
Thank you very much, Mr. Chauhan. Ladies and gentlemen, we now have a video message from an eminent individual joining us virtually today, addressing this gathering. The Secretary General of the ICC International Court of Arbitration, ladies and gentlemen, Mr. Alexander Fassas.
Very warm greetings from Paris and good morning, distinguished guests, ladies and gentlemen. My name is Alexander Fassas, and I'm the Secretary General of the ICC International Court of Arbitration and Director of ICC Dispute Resolution Services. Unfortunately, I cannot join you in Colombo on this occasion. I am nevertheless very pleased for the opportunity to address you today, albeit only virtually. I would like to start with 2 keywords that befit today's occasion. These keywords are growth and progress. I choose to use the words growth and progress as they represent ICC and Sri Lanka in the present and in the future. In the past 2 years, Sri Lanka has made impressive economic growth following a period of economic crisis, as reported by the World Bank and the International Monetary Fund. A commendable 5% economic growth has paved the way for sustainable economic recovery for the country. Such growth is also a testament to the collaborative efforts by the private and public sectors in Sri Lanka. Since its inception in 1919, ICC continues to pursue its mission of purpose and vision of continuity. We make business work for everyone, every day, everywhere, by promoting open international trade and investment to drive lasting peace and prosperity. And at the heart of such mission and vision, the ICC International Court of Arbitration plays a crucial role. Marking its own centenary in 2023, the ICC Court is steadfast in its work in pioneering dispute prevention and resolution, as well as promoting access to justice and the rule of law. In terms of progress, it is worth noting that Sri Lanka is expected to maintain its economic growth in the near future through activities in economic sectors such as tourism, agriculture, exports, infrastructure, apparel industry, and knowledge services. We at ICC and the ICC Court also keep progress at the forefront of our work, in business just generally and in legal services specifically. Unique to ICC's global business outreach is the presence of our national committees in practically all corners of the world. ICC Sri Lanka was set up in 1955 and will soon celebrate its 70th anniversary. Fast forward to today, ICC Sri Lanka remains as active and pivotal in driving business growth and bridging global networks between the country and the private and public sectors from abroad as ever. I must also share that we have seen 20 parties from Sri Lanka in ICC arbitrations, and Sri Lanka itself is chosen as a seat in a total of 8 ICC arbitrations over the past 10 years. ICC Sri Lanka also has made strides in promoting arbitration and ADR in the country at large. In fact, just recently, ICC Sri Lanka established the ICC Sri Lanka Arbitration and Mediation Hearing Center in Colombo, and we hope this will encourage more parties to opt for ICC arbitration, but also for that center to provide a professional venue for any arbitration or ADR hearing and an excellent service that only ICC and its network can provide. I would be remiss to not mention and acknowledge our colleagues from within the ICC Court and ICC Sri Lanka who have been instrumental, not just in promoting the work of ICC in the country, but also in making today's conference possible. Mr. Shanil Fernando helms ICC Sri Lanka as its chairman, Mr. Dinal Phillips is a member of the ICC Court for Sri Lanka, and Mr. Hara Wijanatne is our ICC Young Arbitration and ADM Forum regional representative for Sri Lanka. To all of them, I extend our gratitude and thanks. I would like to share some key updates pertaining to the ICC Court and our own dispute resolution service offerings for your benefit. Back in 2022, we launched ICC Case Connect, a digital case management platform used for all ICC arbitration cases. The platform enables streamlined communication and file sharing among parties, tribunals, and our own case management teams. And it also efficiently stores all case documents and data in a centralized, easily accessible location using swift and using user-friendly features to increase operational efficiency for everyone involved in ICC arbitrations. And since then, we have made further progress to enhance and modernize our online management capabilities with the launch of next-generation platform enhancements, which became fully operational since April this year. 2024 was also the year where we opened the doors of the brand new ICC Hearing Center in Paris. Our own hearing center is equipped with state-of-the-art facilities and is accessible to the members of the global disputes community, regardless of the institutional settings of their arbitration and ADR hearing needs. We are also thrilled to note that our annual statistics in 2024 demonstrate how ICC arbitration and ADR remain preferred dispute resolution methods globally across economic sectors, attracting high-value, high-impact disputes as well as lower-value disputes. My colleague Tejas Shahan, who's our Director for Arbitration and ADR in South Asia, is joining you in person today, and he's set to present the value propositions of ICC dispute resolution services and some of our key figures from 2024. Ladies and gentlemen, our commitment in supporting trade and investment and promoting access to justice and the rule of law for and in Sri Lanka is unwavering. On different occasions, important engagements took place by and with ICC's leaderships in relation to Sri Lanka. To name but a few, in 2024, the Additional Solicitor General Sumati Darunaredda met the President of ICC International Court of Arbitration, Gloria Salomon, at ICC headquarters in Paris. They discussed, amongst others, proposed amendments to the arbitration law in Sri Lanka and on advancing arbitration activities in the countries through the National Committee and its own training programs. In 2023, then ICC Chair Maria Fernanda Garza visited Sri Lanka and reaffirmed ICC's commitment to working not just with the National Committee, but also with key stakeholders in the country and explore areas to implement trade facilitation reform so that Sri Lanka can utilize the expertise, skills, and knowledge that ICC has to offer to private sectors in order to create inclusive economy and multiply job opportunities. I invite and encourage you all to make the most out of today's conference to learn more about not only the work of ICC, but also the importance of arbitration and mediation as tools that support and complement businesses, as well as fostering professional networks. I thank you very much for your participation, and I wish you a very successful.
A very big thank you goes out to Mr. Fassas for that video message. Ladies and gentlemen, it is now my pleasure to invite on stage the President of the Bar Association of Sri Lanka to address this gathering. Ladies and gentlemen, Mr. Rajiv Amarasuriya.
Chairman of the International Chamber of Commerce, Sri Lanka, Lordships of the Supreme Court, distinguished panelists, special invitees, members of the legal community, distinguished guests, ladies and gentlemen. It is both a privilege and honor to address this distinguished gathering at the commencement of the ICC Sri Lanka Arbitration and Mediation Conference 2025. Let me take this opportunity to extend my warm congratulations to the ICC Sri Lanka and its chairman for convening this important event, which could not have come at a more timely juncture. Though I have not been directly involved with the activities of the ICC, I've closely followed your progress with my uncle Mahendra Amrasuri, who was your chairman some time back, then of course Dinesh, and then you, Shanil. As many of you are aware, according to recent figures released by the Honorable Minister of Justice, Sri Lanka's judiciary is grappling with a staggering backlog of 1,131,818 cases. This number is not merely a statistic. It represents individuals, businesses, and institutions, each awaiting justice, each held in suspension until their disputes are resolved. The sheer weight of this backlog challenges both the efficiency and credibility of our justice sector. At its core, this is a question of access to justice. Courts must remain the ultimate guardians of rights and the final arbiters of disputes. But when overwhelmed, they cannot discharge their responsibility in a manner that is timely or effective. This is not unique to Sri Lanka. Many jurisdictions, developed and developing alike, face similar pressures. It is in this context, ladies and gentlemen, that alternate dispute resolution, whether through arbitration, mediation, or conciliation, assumes particular significance. Let me emphasize, however, that ADR is not a panacea. It cannot be the solution to every dispute. Matters involving constitutional questions, fundamental rights, or issues of public law will and must remain within the purview of courts. Yet, for a vast number of commercial and civil disputes, ADR offers a viable, efficient, and often less adversarial path. It is one important tool, among others, that we must sharpen and employ wisely if we are to make justice more accessible and credible in this country. Allow me here to recall the words of Justice Sandra Day O'Connor of the United States Supreme Court, and I quote, "The courts of this country should not be the place where resolution of disputes begins. They should be the place where disputes end after alternate methods of resolving disputes have been considered and tried." End quote. This wisdom resonates far beyond the borders of the United States. It is a reminder that the role of courts should be to provide the final word, not necessarily the first. Globally, arbitration has become the default mechanism for resolving complex cross-border issues. Parties value neutrality, speed, confidentiality, and above all, enforceability. The New York Convention of 1958 has been one of the most successful multilateral treaties, giving arbitration awards enforceability in more than 170 countries. From Sri Lanka, situated at the heart of the Indian Ocean and aspiring to be a regional hub for commerce, the strengthening of arbitration and other forms of ADR is not merely a matter of convenience. It is a matter of competitiveness and credibility in the global economic order. At the same time, we must guard against the temptation to see ADR as an escape from reforming our court system. Arbitration cannot and should not be used to paper over structural weaknesses in the judiciary. Rather, it must develop in parallel with efforts to modernize our courts, digitize procedures, and strengthen the judicial capacity. And that task has now been undertaken. And in fact, last evening, after many years, the provision of using credit cards at the Supreme Court registry was enabled. What we must strive, ladies and gentlemen, for is a balanced ecosystem where courts and ADR complement each other. Courts must continue to play their supervisory and supportive roles in relation to arbitration, enforcing agreements, recognizing awards, and stepping in where procedural fairness is at risk. Sri Lanka today stands at crossroads. With a backlog of over 1 million cases, with a judiciary under strain, and with businesses seeking more predictable and efficient outcomes, the case for strengthening ADR could not be clearer. At the same time, we must resist the narrative that ADR is a Western import. Our own cultural traditions, village mediation boards, community dispute resolution mechanisms, and the religious arbitration bear testimony to the fact that alternative justice has long existed on this island. What we now require is to modernize these traditions within a robust legal framework, aligned with global best practices. This conference, convened under the auspices of the ICC, provides us with an invaluable opportunity to learn from international best practice and experiences, to benchmark our practices against global standards, and to chart a course that positions Sri Lanka as a credible, reliable venue for arbitration in the region. If we succeed, the benefits will extend far beyond commercial parties. A more efficient dispute resolution culture will strengthen public trust in justice, strengthen investor confidence, and ultimately contribute to the national growth and stability. Ladies and gentlemen, as I close, let me return to the words of Justice O'Connor, that courts should be where disputes end, not where they begin. For Sri Lanka, the challenge before us is to ensure that our courts are not weakened, but rather supported by a stronger culture of arbitration and mediation. May this conference mark the beginning of a renewed commitment to justice that is accessible, credible, and timely. I thank the International Chamber of Commerce, its chairman, for organizing this important summit. May the deliberations today lay the foundation for a stronger, fairer, and more efficient system of administration of justice in Sri Lanka. Thank you very much.
Thank you very much, Mr. Amarasuriya, for your words. Next up, bringing in the perspective on the need for a paradigm shift in perceptions and in the adoption of ADR processes as effective mechanisms for resolving commercial disputes, we welcome our next speaker for today. Ladies and gentlemen, it is my honor to invite President's Counsel, Judge of the Supreme Court of Sri Lanka, Honorable Justice Yasantha Kodagoda.
Good morning, ladies and gentlemen. My focus this morning is on a proposal to all of us that we cause a paradigm shift in how we view, in other words, our perceptions of the multiple ADR processes, as well as selecting the most appropriate dispute resolution mechanism for each of the disputes that we encounter. Let us for a moment, ladies and gentlemen, look at the present situation, and my focus is on the situation in this country, in Sri Lanka. The ground reality, ladies and gentlemen, is that ADR, alternate forms of dispute resolution, are not viewed as being a popular choice. In the course of the next few minutes, I wish to present to you my views as to why that has happened. The knee-jerk reaction among the legal fraternity whenever a client presents a dispute is to choose judicial adjudication through litigation. That is the overwhelming choice of the legal fraternity. There is an overemphasis on choosing litigation as being the only effective mechanism of dispute resolution. So there is indeed an overemphasis, though of course litigation has its own merits. All other forms of dispute resolution is viewed by a vast majority of the legal fraternity as being ineffective and weak alternatives. Possibly the only reason as to why arbitration is chosen is because some, and possibly the number of agreements are increasing gradually, some of the dispute resolution clauses in agreements that bind parties necessitate having recourse to arbitration. So possibly that is the only governing reason as to why the legal fraternity would choose arbitration, particularly with regard to commercial disputes. Whatever that was said about the ICC earlier on, I must say a vast majority of legal practitioners as well as disputants themselves do not view arbitration as being an inexpensive choice. Till quite recently, it was not even viewed as being an expedient mode of dispute resolution. Possibly that view is currently changing due to what I see as a new brand of arbitrators who are more sensitive to the needs of disputants now emerging both from the judiciary as well as from among legal practitioners. So as I said earlier, negotiation, both informal as well as facilitated and structured, mediation, conciliation, arbitration are viewed as weak alternatives in comparison with judicial adjudication through litigation. So I present to you, ladies and gentlemen, this proposition that due to both well-founded reasons as well as ill-founded reasons, the choice is not on ADR. The preferred choice among legal practitioners is litigation, and possibly the mindset of disputants themselves don't help in that regard. With regard to this matter, I thought I must, and that I owe it to the conference, to present to you some empirical evidence. I present this empirical evidence somewhat embarrassingly, I must say, but for the purpose of inviting all of you to cause a paradigm shift with regard to how we view the multiple dispute resolution mechanisms. During the last week, I conducted a very brief summary survey about the prevailing situation with regard to resolution of commercial disputes through litigation. And for this purpose, due to the limitations of time, what I did was to select the last 10 judgments delivered by the Supreme Court, arising out of judgments of the Commercial High Court in Colombo, relating to, obviously, commercial disputes. So this is, ladies and gentlemen, the data set that was collected. I've computed the date on which the original action was filed in the Commercial High Court, the date on which the corresponding judgment was delivered by the Commercial High Court, the date on which the petition of appeal was filed, and as you know, from a final judgment of the Commercial High Court, the appeal lies to the Supreme Court, and therefore the date of the delivery of the Supreme Court judgment. The last 10 judgments that I looked at, all 10 pertaining to commercial disputes. This, ladies and gentlemen, was the embarrassing outcome. The time taken for the completion of a trial in the Commercial High Court, an average of 5 years. Time taken for the determination of the appeal, that is from the date of filing of the petition of appeal to the date of delivery of the corresponding judgment by the Supreme Court, 10, which means the complete cycle of judicial adjudication has consumed a staggering 16 years. I know that 5 plus 10 is 15, but due to rounding off of multiple months, it came to an average of 16 years. I know that certain commercial disputes are in fact resolved in the Commercial High Court in quicker time, mainly because counsel encourage parties to settle matters after a couple of years of litigation. So this I present to you as the worst case scenario. Yet we can't overlook this statistical truth that the judicial system would take, if you go through the entire process, a staggering 16 years to resolve a commercial dispute. So, ladies and gentlemen, if this is the ground reality, 5 plus 10 averaging to 16 is the reality, why do legal practitioners repeatedly recommend and advise their clients to choose litigation over ADR processes? That is the question that begs a valid answer. So, I've seen several reasons in my analysis as to why we, the legal fraternity, keep on repetitively recommending litigation. I think the weakness, if I may use that term, starts with legal education itself. All of us who have come through the law faculty, the law college, our focus has been on litigation resulting in judicial adjudication. The subjects have been civil procedure, criminal procedure. So we come from that very narrow mindset that for disputes, the only effective mechanism is judicial adjudication. It was only a few years ago that the Sri Lanka Law College advisedly introduced that again an optional subject, half being arbitration and the remaining half being construction law. And that too an optional subject with other very interesting and useful subjects such as environmental law. So we come from that very narrow mindset of being taught that judicial adjudication through litigation is the only effective means of dispute resolution and possibly the preferred choice. The time is up. I was told that I'll get 15 minutes and not 10. Be that as it may, it's available in writing. So we have a dispute already. So I will fast track. I think the cost, so what else? We come from that narrow mindset, and those of us who have chosen to participate in programs like this over a long period of time gradually accumulate knowledge about ADR processes. It doesn't stem from our core legal education and training. That, I think, is the first reason. The other is that there is, I must say, Shanil, there is this view that arbitration is for a group of elite disputants serviced by an elite group of legal practitioners. You all are laughing because you agree. That is the ground reality. There is that perception also which takes commercial arbitration away from the mindset of regular practitioners who handle a bulk of litigation. The cost, it cannot be overlooked, and I must say that notwithstanding fees that will be applicable, professional fees, that will be applicable to litigation as well, litigation, particularly because institutional services are provided by the state, comes at a lesser cost. There is this issue about inability or extreme difficulties in obtaining interim relief, and therefore litigation is chosen as being a possible gateway to freeze the status quo arising out of the eruption of the dispute. Indeed, in theory, there is provision for interim relief in commercial arbitration as well, but all of us who've been exposed to some amount of arbitration would know very well how difficult or almost impossible it is. We come from a highly litigious environment where the reference to arbitration gets challenged in court, and that means the matter gets diverted back to court, and also the arbitral awards enforcement gets challenged in court. So we live in an era where, yes, there can be recourse to ADR, but it automatically gets channeled back into the court system. There is this aspect, and I think we need to be talking about this. There is a view that party-appointed arbitrators almost always side with the party that appointed such person. There is that perception. Possibly we don't have empirical evidence to test it scientifically, but there is that perception which affects the overall perception regarding commercial arbitration. And there is also the tendency from among legal practitioners to keep on choosing arbitrators who have in the past held with the party that nominated. So these two factors affect the independence, impartiality, and the neutrality of arbitration as a whole in comparison with judicial adjudication. So, due to these multiple perceptions, as I said, both ill-founded as well as well-founded perceptions, there is indeed a heavy bias in favor of judicial adjudication, and ADR mechanisms are seen as being less efficacious in comparison with judicial adjudication. And this is why, unless the dispute resolution clause in the binding agreement compels arbitration as a matter of initial choice, an overwhelming number of legal practitioners will not recommend arbitration to their clients. So, as a possible solution, I think we need to start with this paradigm shift. Not to look at negotiation, mediation, conciliation, arbitration, and contractual adjudication as being alternatives to judicial adjudication. Rather, to keep all dispute resolution mechanisms in par with each other. So, a shift from alternate dispute resolution to what has been proposed by other speakers as well in other fora. Appropriate dispute resolution. To keep all dispute resolution mechanisms in par, this will require re-education, at least for the older generation, and a new way of presenting dispute resolution law to the forthcoming generation of legal practitioners, so that at the end, in our mindset, we have all dispute resolution mechanisms in par, from which, depending on the nature of the dispute, other attendant circumstances, legal practitioners will suggest to their clients to choose the most appropriate form of dispute resolution. So this is, I think, what is necessary. I suggest this as a proposal. I also suggest, ladies and gentlemen, that we encourage legal educational institutions as part of their primary legal education to teach a subject to be called disputes and dispute resolution mechanisms, so that yes, there can be a detailed emphasis on the Code of Criminal Procedure and the Civil Procedure Code, but start by structuring in the minds of law students that this is the entire range of dispute resolution mechanisms. Yes, indeed, there will be pros and cons, and depending on the nature of the dispute, there can be a preferred choice, but start with this appropriate dispute resolution paradigm. So, with regard to the present generation, and I see multiple generations within the current population of legal practitioners, some have some understanding and some have hardly any. And therefore, to continue programs of this nature aimed at increasing awareness, make arbitration services indigenous and freely available. I think that is a must. And in this regard, I suggest that we make arbitration services available serviced in the two vernacular languages as well, so that exclusiveness associated with commercial arbitration diminishes and it becomes an homegrown, locally available, local dispute resolution mechanism. So this is glaring at me. Time's up. It's been up for the last 10 minutes, I think. I would suggest things like court-annexed arbitration centers. Whenever we are constructing a new courts complex, to have a separate room for ADR, may it be mediation or arbitration, to have court-annexed arbitration. Indeed, the hybrids, some of which are available with the ICC. But to end, I would think unless you get the legal fraternity on board, and that is not the chosen few English-speaking legal practitioners centered in Colombo, but the entire legal profession on board, I really don't see ADR thriving in the way all of us would want to. Thank you very much, ladies and gentlemen.
Thank you very much, Honorable Justice Yasanta Kodaguda. May I kindly request you to please remain on stage to receive a token of thanks from the ICC board. Yes. May I also call upon Mr. Tejas Chauhan and the chairman of the Colombo Stock Exchange, Mr. Dimutu Abesekara. For the presentation party, may I also call upon the ICC Sri Lanka board members to please come forward on stage. Thank you very much, gentlemen.
We shall now transition into our first panel discussion on the perspectives on arbitration as a tool for dispute resolution. Ladies and gentlemen, as you may have noticed, on our conference flyer, we have a large presence of distinguished panelists with us today who have come here to support the way forward in the realm of ADR in Sri Lanka. Therefore, these will not be your average panel discussions. To conduct the first panel discussion on perspectives on arbitration as a tool for dispute resolution, it is my pleasure to invite our moderator, Ms. Dhami Fonseca, attorney at law, along with the panelists present here with us today. If I may kindly invite Judge of the Supreme Court of Sri Lanka, Honorable Justice Yasantha Kodagode, Director of ICC Arbitration and ADR Singapore, Mr. Tejas Chauhan, International Arbitrator and Mediator, Dato Jude Benny, Senior Additional Solicitor General of the Attorney General's Department, Mr. Susantha Balapatabendi, Acting Director General of the Board of Investment, Ms. Renuka Veerakon, Digital Economy and Governance Consultant and former General Counsel of Dialogue, Mr. Trinesh Fernando, and the Chairman of ICC Sri Lanka, Mr. Shanil Fernando. We also warmly welcome our two distinguished online panelists, arbitrator and partner of Raja and Tan Singapore, Mr. Lau Kok Keng, and arbitrator and managing partner of SK Ling and Tan Advocates Malaysia, Mr. Tan Ki Heng.
Thank you, Dahara. Ladies and gentlemen, it is my pleasure to moderate our first panel discussion for the day. To give you some context, as we all know, arbitration continues to be a leading mechanism for resolving commercial disputes, valued for its neutrality, efficiency, and enforceability. Yet, evolving commercial realities imposes questions on its effectiveness and adaptability. We have an eminent panel today with us with diverse experience as introduced by Dahara, who will explore judicial perspectives on ADR, the enforceability, the finality of awards, new developments such as third-party funding, new concepts such as artificial intelligence, as well as sector-specific insights, including sports and investment disputes. Our panelists will also reflect on Sri Lanka's potential to position itself as a regional hub for arbitration through reforms and institutional support. All right, it's time to get started. A quick reminder to our dear panelists. As you all know, this conference usually runs over 2 days, but this year we've brought it all into just one. This means we have a lot of rich content to go through, and to make sure we hear from everyone, I'd like to request you all to please keep a keen eye on timing. So each of you will have 4 minutes, and you'll see a timer right in front of you. Once the timer runs out, I kindly ask you to please wrap up your response so that we can quickly move on to the next. One more thing, there will be a question and answer session after the end of all the panel discussions, so you can await that as well. All right. Let's dive straight in. My first question goes out to Honorable Justice Yasantha Kodaguda. In your presentation, you highlighted the need for a paradigm shift in how ADR processes are perceived and used. From a judicial standpoint, what practical steps do you think courts, council, and institutions can take to accelerate this shift and build greater confidence in ADR as a reliable means of resolving commercial disputes?
Well, as I said during the presentation, we have to invest in both the present generation of legal practitioners as well as the generation to come. And with regard to the second category, I think the focus should commence during legal education itself. And I made a reference to that. With regard to the current generation, and I see possibly 3 sub-generations within the current fraternity of legal practitioners, increase in awareness is one. Making arbitration services readily available, I think, is the other. There has to be a shift in how we view arbitration. As I said, arbitration services being available annexed to courts, I think enhances the optics of arbitration. That is, I think, important. And make it more efficacious. Make it more efficacious by changing some of the factors that in fact ail arbitration. For example, a shift from party-selected arbitrators to institutional panels of arbitrators who can be chosen, I think is important. Because that, yes, it does have a negative impact on party autonomy, but it certainly has a positive impact on perceptions relating to neutrality and impartiality. And therefore, a greater shift towards institutional arbitration and panels of arbitrators recognized by such institutions, I think is important. Focusing on the efficacy of how arbitration in fact happens. For example, with regard to industrial disputes, as you know, one category of industrial disputes are in fact serviced by institutional arbitrators appointed by the Commissioner General of Labour. And it works very well. Hardly ever would one of those awards be challenged in a court of law. Not that it doesn't happen, but hardly ever does it happen. So possibly there is something to pick from that mechanism and have subject-specific arbitration services. For example, in the health industry / medical services, cannot allegations relating to medical negligence be resolved through arbitration? So without confining our focus to the resolution of commercial disputes, I think we must have a band of arbitration mechanisms to each of the key sectors of disputes that come to courts.
Thank you very much, Your Honor, for your very practical words. My next question goes out to Mr. Tejas Chauhan. Mr. Chauhan, you have emphasized in your writing that the enforceability of arbitral awards is fundamental if arbitration is to truly deliver its benefits. From the ICC's perspective, what are the main challenges to enforceability across jurisdictions? And how is the institution working towards strengthening confidence in the reliability of arbitral outcomes?
Right. Thank you so much for that question. So there are two aspects to it. Number one is, what can the ICC do to ensure that the awards are enforceable? And that gets me back to the point of scrutiny of the awards that the ICC conducts. And again, what is interesting there is to see that if 10% of the awards are sent back to the tribunal to redraft, that means that at the very least, those awards would have not been enforced, right? Now, I'm not saying that this process is 100% foolproof, because this is also a process which is human. So I'm not saying that there has never been an instance where an ICC award has been set aside. Now, when an award has been set aside, there are two reasons for an award being set aside. Either the court, in its own wisdom, decided not to enforce an award. And I will not comment on that, because courts around the world do things that they think are right. Then the second aspect is that the ICC actually missed something, and there was a lapse on the entire process, which happens rarely. But again, because it's 100-year-old institution, 30,000 cases, there are instances where there might have been a miss. So what the ICC is doing on its own is to strengthen the internal mechanism of ensuring that there are compliance. So what we have, it's a public document. There is an ICC award checklist. So that is the bare minimum that arbitrators are requested or required to follow. And then the court, of course, these are arbitration practitioners that would oversee each and every award to ensure compliance. That is number one. The second is working with courts around the world. Now, there are different requirements that the courts may have that we may or may not agree with. For example, in Vietnam, there is a statutory requirement that the award has to be issued within 30 days of the last substantive hearing. It does not take into account scrutiny. It does not take into account that the institution will have its own mechanism. So courts in Vietnam have set aside awards just on this very ground. But how do you bypass this as an institution? So what we tell the arbitrators is that please do not mark the hearings closed unless the scrutiny and everything else has been completed, right? Because this is something that is a requirement of a legislative reform. The last point is working with judiciary around the world to train and to sensitize them on arbitration. Now, when I say train, judges don't like to be trained, with all due respect, so we call it roundtables and colloquiums. But this is something which is a conversation that we're having with judiciaries around the world.
Thank you very much, Mr. Chauhan. My next question goes out to Mr. Dato Jude Benny. Mr. Benny, what are some of the possible challenges that can arise in using arbitration for dispute resolution, and how can we best address and guard against these challenges?
Thank you. I think the biggest obstacle or hurdle or challenge that arbitration faces is the arbitrator. Because an arbitration is only as good as the person who is managing the entire process. So the user or the stakeholder needs to have a sense of confidence in the entire process and in the arbitrators, which means that you need good quality arbitrators who conduct the case professionally, efficiently, and of course, if you do it in that way, then of course you are also saving costs. So while on the one hand, people tend to think that arbitrations might be more expensive, etc., but what the stakeholder wants is efficient adjudication. And an arbitration in the hands of a good arbitrator should easily be resolved within a year, maximum 1.5 years. And the only reason it's taking 1.5 years is because the lawyers are too busy, and every time you give them a date, they say they can't because they're doing something else. But apart from that, generally, the world today, the commercial world, is moving. This is a force that cannot be stopped. the commercial world is moving towards arbitration because that's what they want. When we originally started, again I come back to the Singapore Chamber of Maritime Arbitration, it was actually part of SIAC, which was institutionalized arbitration. But the shipping world did not want it. And so 2 years down the road, we took SCMA out of SIAC and to stand alone as ad hoc arbitration because the shipping people know what they want. And eventually, it's going to come to dawn that the commercial world knows what they want. They want arbitration because they want people with specific knowledge, specific expertise dealing with these cases in an efficient and way. And they need to know that the court is not going to intervene willy-nilly. You know, I have seen so many cases in different parts of the world at every opportunity. So what's the point? You go through an arbitration, it's taken you a year and a half, and then it gets thrown before the courts, and then it takes another 3 years. The courts need to be arbitration friendly, and therefore the award needs to be final and binding. And the only time the court should be getting in is if there's a breach of natural justice or if there's something so untoward that has happened, fraud or something of that sort. So that at the end of the day, people realize you made your bed, you've got to lie in it, you know. You've chosen arbitration, you've chosen these arbitrators, and with time, people will begin to respect that there are good arbitrators out there who can make very sensible, very experienced people who've been in the game for a long time. They've been lawyers for 20, 30 years. I don't know, and many of them have gray hair or no hair. So these people know what they're doing, and people begin to respect the process. So that is the challenge it faces. Arbitration needs to get credibility, and you only get that if and just one other thing, I know time's up, is that, you know, we say lawyers. No, it's not lawyers. It's the one before the lawyer. It's the client. The client, the business people, the ones who are paying the bills, they are the ones who should be educated. We should be going on roadshows telling business people, use arbitration for this reason, and this reason. And then they will tell their lawyers, I want arbitration. Why are you sending me to the courts? So that, to me, that's the way to go.
Thank you very much, Mr. Benny, for the thought-provoking response. My next question goes out to Mr. Susantha Balapatabendi, PC. What are your perspectives on the effectiveness of arbitration in resolving disputes, taken in the Sri Lankan context?
Yeah, just to answer that question, let's take an account of the volume of arbitration in Sri Lanka. As of December 2024, the number of cases pending in the Commercial High Court was 8,913. Out of this 8,913, the arbitration-related matters was 6,882, which is about 76% of the pending cases in the Commercial High Court. So, just want to take the point further, which Justice Kodagod highlighted, whether we have given enough emphasis to arbitration in our legal curriculum or not. We need to ascertain all the arbitration cases pending are more or less enforcement and setting aside applications. The number of company law cases pending in the Commercial High Court is 302 as of December 2024. Intellectual property was 156. Now, when you compare with the IP, company law, with the arbitration, arbitration is the highest number of cases, which is about 76% of the pending cases. So, as very correctly Justice Kodagode pointed out, it's an optional subject. Whether we have to make it a mandatory subject or not is something that we need to look at it. The Council of Legal Education will have to seriously think about it. The second point that Justice Kodagode also highlighted in his presentation was whether the ICC is a elite dispute resolution mechanism. One of the arbitrations that I have handled, an investment arbitration for the Board of Investment, the issue that I had was from the very beginning was whether the witness can give evidence in Sinhala or not. The witness specifically told me that I'm comfortable in giving evidence in Sinhala. So the issue was whether that is possible or not. We all know that that is possible in courthouse, but whether that is possible in arbitration, especially in ICC. This was ICC arbitration. So that is possible. A lot of people might think that Sinhala-speaking witnesses may not be a suitable witness in ICC. ICC facilitates translators if necessary. So don't think that ICC is a elite's means of effective dispute resolution. It's not the case. So my time is up. So I wanted to reiterate the fact that it is important for us to understand the importance of ADR, take into account of the number of cases pending as of 2024. Thank you.
Thank you very much. My next question is directed at Mr. Lau Kok Keng, who will be joining us online. Do we have? Yes. So the question is, what are the key advantages of resolving sports-related disputes through arbitration rather than through traditional litigation? Are there any such disputes which national courts should avoid?
Thank you for your question. It's a question that needs much more than 4 minutes to answer, but I will just share with you a few key points. On the use of arbitration to resolve sports-related disputes. Well, firstly, we're talking about speed and efficiency, and particularly in sports arbitration, it is designed to deliver decisions very quickly, and speed and efficiency is crucial because athletes' careers are very short. The timing of competitions may mean that delayed decisions can affect the outcome or render the outcome meaningless. So, for example, whether an athlete is eligible to compete in a certain event, it may depend on the outcome of an appeal against the sanctions imposed by the athletes, and it may also affect the ability of the athlete to compete in the next match. So, for example, in 2017 at the SEA Games in Kuala Lumpur, Southeast Asian Games, I was part of an arbitral tribunal that was convened to hear an appeal against a sanction imposed against an ice hockey player from the Philippines. And we had 6 hours to constitute the panel to hear the appeal and to render the decision. And whilst we were deliberating on the decision, the Philippines and the Thai ice hockey teams were lined up to play in the final. And our decision had a bearing on whether or not the captain of the Philippines could appear in the match. We have a specialist sports arbitral tribunal in the name of the Court of Arbitration for Sport. And they do provide ad hoc tribunals during major sporting events like the Olympic Games and the FIFA World Cup. And these tribunals offer 24/7 access and they issue decisions within 24 hours. And certainly resolving sporting disputes through these ad hoc tribunals is much more practical than going to courts, apart from the fact that such a dispute resolution process is actually mandated as a requirement for participation in the event. Then there's also the specialist expertise that is required in a very niche area of practice like sports law. So sports arbitration panels usually comprise experts in sports law and sometimes even experts in the very specific sport in question. So this ensures that there is a thorough and nuanced understanding of the applicable rules and their application, which I think, with all due respect, generalist commercial judges may lack. So the determination of sporting disputes is often, something that needs to be handled by judges with such specialist expertise. So, for example, in the case of an employment dispute between, say, a professional footballer and a foreign club that he's contracted to play for. When I was on the Court of Arbitration for Sport, I heard some of these disputes, and it may surprise you that the governing law of the contract is totally irrelevant. What's important and what governs is the FIFA regulations on the status and transfer of players. And this is the regulation that provides the overarching framework for player contracts and transfers. So even if your employment contract provides for termination by giving the player 1 month's notice, that's not allowed under the FIFA regulations, which instead require that just cause be established for every type of termination by the employer club. And then there's also the international dimension of sports. So sporting disputes are often cross-border in nature. It involves parties from different countries. So if they come from different countries, it would certainly be unfair if a court from the country of one party were to resolve their dispute or to make a decision. So sports arbitration would provide a neutral international forum to address potential bias issues, to avoid issues of conflicting national laws and also issues of jurisdiction. As for your other question about what disputes national courts should avoid, now I think a general proposition would be that national courts are generally reluctant to interfere with the way sporting organizations manage their internal affairs. Perhaps it is due in part to a lack of familiarity with the processes and the practices of the sporting world. So sports organizations are generally given a relatively wide latitude to govern their own sporting affairs, including team selection, discipline, and eligibility. And national courts usually only intervene after all internal remedies have been exhausted, and even then, only on limited grounds such as procedural unfairness, a breach of natural justice, or compelling overriding public policy. Now, specifically, I can think of 3 types of sporting disputes which national courts should avoid. The first, obviously, is when there is an arbitration clause. In major sporting events like the Olympics and the World Cup, all teams and all participants are bound by certain set of participation rules, and those rules say that sporting disputes arising from the event must be resolved through the ad hoc tribunal that's constituted by CAS. And then secondly, it's field of play decisions. Now, these are decisions that are made by referees or officials during the course of a match or a competition. And the reason for national courts avoiding interfering with such decisions is in order to preserve the autonomy of the sport, finality of the results, and integrity of the competition. So field of play decisions are therefore generally considered to be non-justicial matters before national courts. And even sports arbitral tribunals have consistently held that they will not review field of play decisions except in cases of fraud or arbitrariness or manifest error. And this is for 3 reasons. The first is a practical one. If you start to correct on-field errors through litigation, it would paralyze the game. It would overturn results and create uncertainty for the fans, for the broadcasters, and for the bookmakers who have already paid out on the basis of certain results having been registered. The second is institutional. I think officials are presumed to possess the specific expertise and situational awareness that generalist judges lack. And the third is, I think, grounded on policy, which is that the sport's legitimacy depends on finality. So once the final whistle blows, with very narrow exceptions, such as if the team had fielded an ineligible player, the decision of the referee or the official will stand, and it's not something that the courts should intervene in.
Thank you very much, Mr. King, for your descriptive answer. I'd like to direct my next question at Mr. Trinesh Fernando, a rather timely and ever-evolving topic, I must say. This question is, how can arbitrators and institutions leverage the efficiency of artificial intelligence without compromising the fundamental principles of confidentiality, procedural fairness, and the human element essential for resolving commercial disputes?
Yeah. Thank you. Good morning and thanks for having me here in this panel. I would like to start by sharing a timeline, adaptation timeline over a century. So the dates are 1903, 1914, 1919, 1923, 1958, 2021, 2022, and 2024. So 1990 ICC starts. 1923 ICC set up the Court of Arbitration. Then 1958 New York Convention. Then 1921 2021 latest update to the ICC arbitration rules. And 2022 Case Connect, that's a digital platform that ICC set up. And 2024, ICC publishes an overarching narrative on AI. It's a narrative. So there were two dates that I didn't mention to you, I explained to you. That is 1903, Wright brothers invent flying airplane. And 1914, autopilot invented, Lawrence Perry. So, Daro, Jude, a question for you.
I'm not a pilot.
Yes, but you flew in last night.
Okay, so that
When you got into
qualifies
the
me.
plane, did you ask to see the pilot?
No.
Right. And did you know when you are flying 35,000 feet that autopilot is on or human pilot is on?
I'm guessing that the autopilot is on.
Yes. So, point is the trust. Over 100 years, the trust is there, and technology needs trust. The first thing I want to highlight is that. So, when you book your last flight, an algorithm actually set the price. But if there's a dispute with regard to that airplane, right, you would actually get ICC arbitration to do that decision or resolve the dispute. That is because a decision needs to be binding, confidential, and fair, and delivered by humans and not by machines. So binding nature is one item, that is trust in the award. So AI can help organize submissions, check consistency, even support awards scrutiny, but cannot help in deliberation or decision. ICC rules make it very clear that arbitrators must personally decide and personally sign. So one case come to mind, recent one, 2023, Mata versus Avianca. Mata versus Avianca. It's where one of the lawyers actually filed submissions with fake citations of fake cases. And the sanctions were put on the lawyer and the case was withdrawn. And that actually gave rise to the Silicon Valley Arbitration and Mediation Center guidelines, which actually guides if lawyers are using AI to the way that you have to have control. Then confidentiality, protecting sensitive data is one of the key items that litigants would actually go, business parties would go for arbitration. So AI can help in transcripts, translations, ICC Case Connect platform through that. Then AI cannot help in upload case files into public AI domains. You cannot do that. So one guideline in the SVAMC in Silicon Valley is actually, would you be prepared to disclose that you used AI in drafting your submissions? So if it is actually impacting the judgment or the decision, it is guiding, guidelines say that yes, you need to disclose, and not only one line disclosure, you need to disclose the tool, the prompt, and the output. So 2 minutes only. Efficiency. This is like 4 minutes became 3 minutes, right? So I am claiming my 1 minute. Okay. So efficiency, the governance path, right? Because arbitration is efficient. AI can help in even predicting coding in disclosure, right? Smart scheduling and real-time transcripts, but cannot do override fairness. Outputs must be verified, parties treated equally. And these are all embedded today in ICC rules. And governance path that you need to choose is actually a path which is modular, that you get into in a tiered way in adapting AI. Then there is one key item that we need to really embrace, that is AI literacy. Without AI literacy, you cannot actually embrace it and you cannot use it. You will not know the boundaries or the guardrails or the human in the loop requirement that you need to embrace, especially in a thing like arbitration. So Singapore has already started training judges and lawyers, and the EU Act makes literacy mandatory for regulators. And interestingly, from 1st of September in China, AI literacy or AI education is mandatory for schoolgoers and starting as early as 6 years old. Then so finally, what is it? So how can arbitrators or institutions leverage AI? By actually remembering the can do and cannot do. AI can accelerate case management, disclosure and efficiency, but cannot decide. It cannot compromise confidentiality, and it cannot replace human judgment. ICC rules give us the guardrails, and global practice give us roadmap. AI will serve arbitration but never replace human integrity, and makes arbitration a trusted tool for dispute resolution. Thank you.
Thank you very much, Mr. Fernando. My next question is for Mr. Tan Ki Heng, who is joining us online. Mr. Heng, what is your view on the finality of an arbitral award when viewed in the light of the possibility of being set aside by the court?
Ladies and gentlemen, good afternoon in advance from Malaysia. First of all, I must apologize for my absence in presence for this conference in this beautiful Sri Lanka. Yeah, in both domestic and international arbitration, it is recognized across any jurisdiction that an arbitral award is final and binding on the parties. This leaves the parties with limited recourse to judicial challenge in the court. The emphasis on finality in arbitration means that the dispute must be determined through a fair, impartial, and equal process, especially when the parties are generally not conferred with the right of an appeal against an arbitral tribunal decisions on the merits, unlike in a civil court litigation, where generally the parties have the vested right to appeal to an appellate court. Now, the statutory regime of the arbitration law in many countries detect minimal intervention by the courts. Due recognition must be given by the courts to the purposes of encouraging arbitration as a method of ADR and facilitating the recognition and enforcement of arbitral awards. The courts do not and must not interfere in the merits of an arbitral award, which may give the losing party a second chance to articulate the merits of their case. In Malaysia, Singapore, and Hong Kong, this basic trade principle is reflected in the policy of minimal court intervention in arbitral proceedings. Indeed, to ensure minimal intervention, or ideally, no intervention at all by the courts, the statutory provision in arbitration law of many countries set out the procedure which must be followed and complied with not only by the arbitrator, but also by the parties involved in the arbitration. Now, however, it is also beyond any dispute that such finality in the arbitration regime is not absolute. It is just like no king or no president in any democratic country is above the law, though apparently certain president of certain country may think he is. Therefore, an arbitrator does not have absolute power to decide without any legal boundary or restraint, like for Malaysia. Luckily, the arbitral award, which ordered Malaysia to pay nearly USD 15 billion to the heirs of the Sultan of Sulu, was recently set aside by the court in Paris based on the successful challenge by Malaysia on the ground that the arbitration tribunal was irregularly constituted and had no jurisdiction. Now, in this, it is equally important to have a mechanism to set aside an arbitral award through a court of law. However, court intervention is very limited to statutory grounds and must be restricted to exceptional instances such as lack of jurisdiction, the award is tainted with fraud or corruption, breach of rules of natural justice, and on the ground that the award is incomplete with public policy of the country concerned. However, on this public policy ground, I must tell you, it's a very wide area to be discussed in view of the fact that the definition of public policy can be very subjective, particularly in different countries with different jurisdictional background. Now, in conclusion, to promote arbitration as an effective ADR platform, there must be a good balance between the finality of an award and the recourse to set it aside by taking into account the interests of all the stakeholders, particularly the interests of the legal consumers, also where there is no doubt that once the setting aside is commenced in the court, coupled with the usual appeal avenue to the appellate court, it may take for at least another 2-3 years, not to mention average time of 10 years for the appeal mentioned by Justice Jasanta earlier. In Malaysia, Singapore, appeal normally we can take it within 2-3 years, right? And this may defeat the very essence of arbitration as a swift, effective and efficient method of ADR, and also the advantage of confidentiality in arbitration is diminished, since salient facts and details of the case will become public under the principle of open justice when the case comes to the court, particularly when the judgments are reported, although the names of the party may be abbreviated. And then what is left? This may only create the impression that in arbitration, there is only one thing for sure, that a sure win for the arbitrator and counsel insofar as the lucrative fees which they can earn, regardless of whether you think yourself we think ourselves is the cheapest lawyer or not in town. Thank you, everyone. Thank you.
Thank you very much, Mr. Heng. My next question is directed to Ms. Renuka Virakon. Ms. Virakon, what is the strategic perspective of the Board of Investment on leveraging arbitration, applies both domestically and internationally, as a critical tool to build investor confidence? And to add to that question, also, what specific reforms or initiatives are you championing to make Sri Lanka a preferred destination for the resolution of investment-related disputes?
Yes, let me start by sharing some OECD statistics, which shows that 93 to 95% of investment agreements contain investor-state arbitration clauses. And this reflects that the predictability, transparency, and confidence bestowed on investors with respect to protecting their rights in terms of their investments. And it also increases the host state's credibility and commitment towards its foreign investments. So with these figures, we see that arbitration remains to be the preferred dispute resolution mechanism for investor-state dispute settlements. The BOI, from its inception, has been an active advocate of arbitration, and we have embedded arbitration clauses in our investment agreements under Section 16 of the BOI law. And this has provided a mechanism for investor-state disputes to be resolved through arbitration within predictable timelines. Actually, Mr. Susanth Balapatimadhi also referred to one of the ICC arbitrations we had with one of our investors. And I think many of the panelists have also touched upon the need to have sector specialists to address arbitrations. Because if you look at the BOI, we have projects in various sectors. It could be in the construction sector relating to infrastructure, manufacturing in diverse sectors, IT related, etc. And it is important that the arbitrators are sector specialists in those fields to be able to look at the disputes that have arisen and to arrive at proper conclusions. And we believe that the ICC South Asian Arbitration and Mediation Center, which was launched yesterday, will also increase Sri Lanka's visibility as an arbitration destination in the region. As such, moving forward, we would like to see more commitment from the center to conduct arbitrations on a full-time basis, expediting dispute settlements and the process reducing the time taken. I'll also like to share that further to a budget proposal that was introduced last year. A new act is being proposed for investment protection. And in this, it is looked at that where arbitration clause can be also embedded. And this would be a good signal for international investors to know that there is a legislation in force that would protect their investments, and the framework for ISDS is already spelled out. So I think that would be a very good mechanism for the BOI as an investment promotion agency to also give the confidence and comfort to investors that they would have this mechanism available for them when they are operating in the country. Thank you.
Thank you very much, Ms. Virakon. My final question for this panel discussion is directed at Mr. Shanil Fernando. Mr. Fernando, what are your experiences handling ICC-managed arbitrations here in Sri Lanka?
Well, I'll make this very short because of the time constraints. Well, I would say that for the ICC, my experience doing ICC arbitrations is that the process is well done, and you have to follow that process, number one. And then the other one is you need to, when you are going in for an arbitration, the client should select a lawyer who is like specialized in that area. There are construction arbitrations, software arbitrations, IP arbitrations, and so on. Then that lawyer goes and selects an arbitrator who knows that subject. Say, for an example, the investment arbitration we did. I flew to Singapore and was looking for an arbitrator. And then I was introduced to Dr. Jude Benny. That is how he became our arbitrator. At that time, I didn't know him. So similarly, if you want an arbitration to be done properly, you need to sit 8 to 5. We sat 8 to 5 in Sri Lanka. We had a British lead arbitrator. And it is very well monitored. At that time, the case management came from Paris. And I think it is now better managed from Singapore. So what I could say is that you need to select, though there is this concern that when I spoke to some of the legal counsels about 2 weeks ago at our center, they were saying arbitration has been a failure. It has become a failure because of the way it is conducted and the persons whom you are entrusting your work to be conducted. So you need to look at, are these the persons who you are hiring out, their reputation, is it being dragged on, or is it somebody who gets it done quickly and finishes off, right? So I think let's leave it at that, so that you can pass on the mic to the others. Thank you.
Thank you very much, Mr. Fernando. With that, we end the panel, the first panel discussion for the day. Thank you very much, ladies and gentlemen, for your valuable insights and recommendations. Over to you, Dahara.
Thank you very much. As mentioned by the Hammy earlier as well, we will open the floor to a few question and answers at the end of the event. I hope you do understand that we have a very diverse panel of a lot of speakers, so we do need to accommodate everyone here today. So please do make a note of whatever question you wish to ask, and we will have that opportunity given to you at the end of the session. Thank you so much, and thank you to our distinguished panelists. If I could kindly request you to remain on stage for the distribution of the tokens of appreciation. I would like to invite Mr. Chanil Fernando and the members of the ICC Sri Lanka board to please come forward and present the token of appreciation to our distinguished panelists here today. Thank you very much to our distinguished panelists. Now over to you, the Hemi, to take over.
Thank you once again to our esteemed panelists and our moderator. Moving on, ladies and gentlemen, we have another esteemed individual joining us today to share his insights on the powers, duties, and obligations of the Arbitration Tribunal. Ladies and gentlemen, please welcome international arbitrator and managing partner of PSL Advocates and Solicitors, Mr. Samir Jain.
Good morning, Honorable Judges of the Supreme Court, Mr. Fernando, Chairman of the ICC Sri Lanka, Tejas Chauhan, Director, South Asia ICC, members of the board of ICC Sri Lanka, Abhinav, ladies and gentlemen, good morning. I was given the task of explaining the rights, obligations, and duties of an arbitrator in a span of 15 minutes. And I was told there'll be a bell which will ring after 15 minutes, and if I don't stop speaking, the mic would be switched off. But so when I was making my presentation, I couldn't help but recall the lines by Blaise Pascal in his book called The Provincial Letters, which said that I have only made this letter longer because I haven't had the time to make it shorter. So while I was making this presentation, and since I've had some time, I've tried to make it short and crisp, and I hope I finish this within 15 minutes. The ambit of rights, obligations, and powers and duties of arbitrator is very wide. And I will focus today's talk on the ICC rules, the 2021 rules, which I believe are one of the most comprehensive and forward-looking arbitral institution rules, which encompasses within itself express rules on rights, obligations, and duties of an arbitrator. It is well known with rights comes duties, and while an arbitrator has many rights within its ambit to control the process of arbitration, it also has certain obligations. The ICC rules of 2021 within itself have more than 10 rules only specifically talking about what are the rights, obligations, and duties. And within its rights, there are multiple rights of the arbitrator. For example, Article 22 of the ICC rules talks about procedural autonomy. Now, when we talk about the difference between an arbitral process and the court process, the cornerstone of the arbitral process is the flexibility which an arbitrator can bring in to the process of arbitration. And when you choose to arbitrate with the ICC rules give powers to the arbitrator to make the rules flexible and gives an autonomy under Article 22 for an arbitrator to fix the process and procedure of arbitration to make it amiable, to make it more comfortable for the parties to arbitrate. Now, imagine a situation where there's an arbitration between parties where a party clearly has all the means to submit documents online, to have an online hearing, as against a party which does not have so. What do you do then? In a court process, the court normally is bound by the rules of procedure, the laws which binds the court to act in a certain manner and not in any other way. This is not the case in the arbitration process. An arbitrator or a tribunal can devise the rules and the procedure in such manner so as to make it very convenient for the parties to arbitrate, where all parties feel comfortable. And that's what Article 22 gives the tribunal the right of. For example, Article 25. Rule 25 also gives the tribunal a right to manage the evidentiary process. Now, whether to have an evidence in a particular matter, whether to not have an evidence, that is to have a documentary only evidence, documenting only arbitration, whether to have an oral examination, cross-examination, to not have such, to have it online, to not have it online. These are all well within the powers of an arbitrator to choose. From personal experience, I was doing an arbitration governed by the ICC rules. It was seated in Paris. The evidence which was given by one of the witness was accepted by the tribunal, and there was supposed to be a cross-examination. There were 14 witnesses. All 13 witnesses were physically present. And the 14th witness was unfortunately succumbed and was in the hospital and could not travel to Paris. The development happened only 2 days back, so we did not have the chance to let the tribunal fix or refix the dates. What did the tribunal do? The tribunal molded the rules, molded the procedure, and had the cross-examination of that witness not on VC, but on phone. We had the witness on the telephone, and the witness from the hospital deposed to the tribunal, and that is how flexible the rules and procedures are, and that's what the power of an arbitrator or the tribunal is in an arbitration. So they can very well have the procedure molded, the evidence control, and so on and so forth. As against all of that, the tribunal also has the power to provide interim reliefs. Now, as everyone is aware, interim relief sometimes is the cornerstone of any dispute. You have to protect the subject matter of arbitration. You have to protect the monies involved in the arbitration. And in an appropriate case, an arbitrator has the power to give such interim reliefs. Now, the power of interim reliefs has to come from the rules, and these rules do provide wide powers to an arbitral tribunal to give interim reliefs in an arbitration. Now, the nature of these powers can be in the form of a status quo, the nature of these orders can be in the form of a preventive reliefs, the nature of these powers can be in the form of deposits or injunctions. Now, Article 24 also talks about case management. Now, case management is at the beginning of the arbitral process. It's a very important step. That is where the whole counters in which a proceeding will be undertaken is decided. Now, case management conference happens at the initial stages where both parties have a conference with the tribunal, and the tribunal decides with the comfort of all the counsels from the parties, and then fixes the process and procedure of how the arbitral proceeding in that particular matter will be taken up. Now, with all of this within the realm of the ICC rules, you can only imagine the power and the power of the process where the tribunal has within itself to govern the process of arbitration, to make it so comfortable that parties end up choosing arbitration over courts. Now, with this, there are certain obligations as well. Now, each tribunal has an innate obligation to conclude the matter in an expeditious and a cost-effective manner. Now, efficient does not always mean quick. Efficient means the quickest it can be. Now, I will shortly also talk about the whole concept of due process paranoia. Now, efficient means the manner in which all parties consider heard, all parties consider that the process has been fair to them, and all parties consider that the process has been efficient to them. And cost-effective also comes within that ambit. The obligation to have the arbitration expeditions cost-effective is also one of the most important aspects when parties end up choosing arbitration over courts. Alongside, the arbitrator also has, or the tribunal also has, the obligation to be independent and have the disclosure. Now, independence obligation is based on the fundamental principle where an arbitrator is required to disclose any fact or circumstance that may question the independence or create reasonable doubt. The key point here is reasonable doubt. It is not upon the arbitrator to know to himself or herself that he or she is independent. The key is whether the parties or an independent person who looks at the circumstances in which the arbitrator is, whether that person would have reasonable doubt as to his impartiality. Now, it may so happen that when it is required for an arbitrator to disclose circumstances, the arbitrator thinks to himself or herself that, okay, I'm independent. There may be some circumstances, but that doesn't impact my judgment. I'm sorry, that's not what the standard is. The standard is whether if that circumstance was disclosed, would a party, an independent party, have reasonable doubt as to the independence of the arbitrator? And if from the third person perspective, there would be a reasonable doubt without actually determining whether there's independence or not, that circumstance needs to be disclosed. And the third and the most important obligation of an arbitrator or a tribunal is of fairness and impartiality. An arbitrator must be fair, impartial, and I cannot impress more upon this fact that that is the most important obligation of an arbitrator. Now, the independence standards are contained in Article 11 of the ICC. Then there is a fair process, which is required under Article 22. There is a whole appendix, which is Appendix 4 to the rules, which is on the case management techniques. And it is very, very important. I have come across certain cases where people sit as arbitrators in an institutional arbitration, but have not read through the rules completely. It is extremely important for anyone and everyone, whether you are a counsel in an arbitration or an arbitrator in an arbitration, to threadbare read the rules of the institution under which you are sitting as a counsel or as an arbitrator. Due process paranoia. I think due process paranoia is something which everyone gets hit on. Now, due process paranoia is when a tribunal thinks, if I am to not give a chance to a party to make submissions, to make arguments, to lead evidence beyond a certain point, will my award be challenged? And in the threat of whether my award will be challenged or not, the proceeding gets elongated. And that's the paranoia which hits every arbitrator at some point or the other. And that is what we call the due process paranoia. This apprehension of potential challenge to the award needs to be overcome. And when this apprehension gets overcome after experience or after knowing that there's certain level of fairness or certain level of expediency which needs to be maintained, there is when you overcome the concept of due process paranoia. I think due process paranoia is something which really can delay the process of arbitration or make it inefficient. And the Supreme Court Court of Appeals in China Machine and Jaguar case expressly said that parties' right to present its case is not absolute and requires adherence to tribunal's procedural directives. Now, certain case laws which just hits on the principle which we discussed. The first is the Sri Lankan Supreme Court case of Singer Industries versus Ceylon. The facts were very simple. There was a dispute on payment of gratuity. The High Court ruled, upheld the award, where the tribunal said that there was an oral agreement to pay gratuity over and above the statutorily required gratuity. The Supreme Court overturned the award, saying that arbitrators are not wild horses. They have to keep the evidence in check. They have to decide on the basis of the evidence, and which then underpins the most important aspect of tribunal's duty to rule basis the evidence. The Halliburton case, the most famous case on the disclosure requirement of an arbitrator. Here, the arbitrator did not disclose that he sat as an arbitrator with one of the parties to the arbitration in multiple cases. Though the arbitrator was not removed by the Supreme Court. My time's up, and I will close within 1 minute. Though the arbitrator was not removed, the court really emphasized the importance of disclosure and the importance of an independent third party thinking whether there would be an apparent bias in a particular case. The Supreme Court Court of Appeals in CJA versus CJIS talked about, again, deciding the case basis the pleadings and evidence. The most important distinction which was drawn in this case is arbitrators are not court of equities, and arbitrators are the creatures of the contract, and the contract is the sacrosanct constitution, which is the only thing which the arbitrators need to consider. Now, in summary, the key principles in the rules, in the rights, obligations, and responsibilities of a tribunal are adopt fair procedural measures for effective case management, control the evidence, have a judicial approach, have a mandatory obligation to conduct the proceedings expeditiously, maintain fairness, provide reasoned, well-written awards, and avoid bias at all cost. Now this, ladies and gentlemen, in summary, is the rights, obligations, and duties of an arbitral tribunal. Thank you.
Thank you very much, Mr. Jain, for your words. Next up, we have another interesting topic that we'd like to venture on, and it's on the use of med-arb-med in international arbitration. To enlighten us all on the topic, I kindly invite international arbitrator and director, foreign law of Drew and Napier, Singapore, Mr. Abhinav Bhushan.
Firstly, thank you so much, ICC Sri Lanka, for bringing me back to Sri Lanka. It's always a pleasure to come back. Honorable judges of the Supreme Court, members and office bearers of ICC Sri Lanka, Mr. Tejas Chauhan, Director of ICC Arbitration, Mr. Jain, Dato Jude Benny, distinguished guests, old friends and new, thank you once again. I start with the topic. The topic is, of course, med-arb-med. And before I delve, for what I have about 15 minutes into the topic, may I ask in the audience, has anybody in the audience has actually conducted a formal mediation process? By show of hands. Some, not too many. I know I'm not going to ask how many people have actually done arbitration, but how many people in this room have actually combined mediation with arbitration and then coming back to mediation? There's at least one gentleman who's done that. Excellent. So today we are actually going to talk about this fascinating combination of what can be achieved by what we know as med-arb-med. It could be arb-med-arb. It could be a med-arb. It could be an arb-med. But just before we take a step back, Sri Lanka is no sort of it's not unknown in Sri Lanka. The concept of mediation has been prevalent in Sri Lanka for a very, very long time, whether it was the Gam Sabhas, whether it was the 1988 mediation boards, and the country, the civilization, the laws are very well adept and very well understand the concept of what mediation can bring to a dispute resolution process. Of course, mediation, unlike arbitration, is still in the formative stages in the world, and you're all aware of the Singapore Mediation Convention, and countries are more formally adopting the concept of mediation and the process of mediations. People talk about arbitration, and often it is said that an arbitration is only as good as an arbitrator, right? Some people say that an arbitration is only as good as those who are involved in it. But you know, there is, of course, a new understanding that a dispute is only as good as parties' willingness to resolve it. And that's where mediation really comes handy. In fact, I will talk about it in my presentation, but having spent myself 10 years at the ICC, 5 years in Paris and 5 years in Singapore, until Mr. Chauhan planned a heist to take over my job and became the director, I had the privilege of overseeing arbitrations as well as looking into mediations. And you'd be surprised to know that if you were to delve into formal mediation by formal mediators before you venture into arbitration, your success rate of a settlement is almost 50%. those disputes which actually go into mediation before they go into arbitration, parties actually end up settling those matters, and therefore avoiding the cost of litigation, and the difficulties that come with arbitrating and going through the full length of 1 or 2 years, or how much ever time it may take in an arbitration. All right. Never mind. Just to be more sort of, efficient with time, I'll anyways talk about my presentation. So what is mediation essentially? Right, we're talking about med-op-med, and this is an introductory talk. I possibly cannot cover the contours of either med-op-med or even mediation in 15 minutes, of which I've already taken about 5 to 7 minutes. So mediation essentially is a flexible and a consensual technique in which a neutral facilitator helps the parties reach a negotiated settlement of their dispute. The parties have control over the decision to settle and the terms of any agreement. As a contrast, an arbitration, of course, as we know, is a formal procedure leading to a binding decision from a neutral tribunal susceptible to enforcement pursuant to the New York Convention. We've all talked about that. A med-op-med is a hybrid dispute resolution process, combining mediation and arbitration, and sometimes that arbitration returns to mediation after the arbitration begins. So you have options like med-arb or arb-med, subject to how, of course, the parties and the cases are shaping up in the first stage, and also having regard to the parties' commercial objectives, projected legal spend, and timelines. Now, I'm sure all of you would agree that in order to get into it, you need to have a contractual framework to get into any form of formal mediation. And in order to have that contractual framework, you need to have a formal mediation clause in the contract, without which you will not be able to compel either party to either do arbitration or, for that matter, mediation. And the ICC, of course, if you look at the ICC rules of arbitration, I think it's probably the only institution that I'm aware of where the ICC rules of arbitration and the ICC rules of mediation are a part of the same booklet. So you will find ICC mediation. So there are various model clauses that ICC has that you can actually put into your contract in order to do med-arb, or arb-med, or mediation before arbitration. And there are four options there. One, in the model clause, and I'm going to talk about it, the possibility of using mediation. 2, the obligation to consider using mediation. 3, mediation and arbitration used simultaneously. And the fourth option is mediation and arbitration used successively. And we're going to just run through the clauses very quickly. So the Model A clause is the option to use, and the language goes like, the parties may at any time, without prejudice to any proceedings, seek to settle any dispute arising out of or in connection with the present contract in accordance with the ICC mediation. Now, this is giving an option to the party. I mean, I'm not entirely sure if this is going to be very helpful if you want to use mediation, a formal mediation process in your dispute resolution clause in the contract. Clause B, obligation to consider the ICC mediation rules. In the event of any dispute arising out of or in connection with the present contract, the parties agree in the first instance to discuss and consider, no, not quite good enough, referring the dispute to the ICC mediation rules. Perhaps what might be more helpful is to look at the Clause C and Clause D, that is obligation to refer disputes to the ICC mediation rules while permitting parallel arbitration proceedings if required. And the clause goes, in the event of any dispute arising out of or in connection with the present contract, the parties shall first refer the dispute to proceedings under the ICC mediation rules. The commencement of proceedings under the ICC mediation rules shall not prevent party from commencing arbitration in accordance with subclause Y below. And Y says all disputes, of course, arising out of in connection with the contract shall be finally settled under the rules of arbitration of the ICC International Chamber of Commerce by one or more arbitrators. So essentially what's happening in this clause is that you shall initiate mediation, but that does not prevent you from initiating arbitration parallelly. And Clause D, obligation to refer disputes to ICC mediation rules, followed by arbitration if required. And this says, in the event of any dispute arising out of or in connection with the present contract, the party shall first refer the dispute to proceedings under the ICC mediation rules, full stop. If the dispute has not been settled pursuant to the said rules within 45 days, and you can tweak the number of days here, following the filing of a request for mediation, or within such other period as the parties may agree in writing, such dispute shall thereafter be finally settled under the rules of arbitration, in accordance with the said rules of arbitration. So what's really happening in Clause 2E is that you are obligated to first finish the formal mediation process, and should that not come in a resolution, you then file an arbitration. Now, there are, of course, key features to this, right? I mean, I have done cases where an arbitration started, went on for about 6 months, say sometime after the filing of statement of claim, statement of defense and counterclaim, the party said, look, hang on a minute, I think we have a better sense of what's really going on. We don't want to go through with the red fern and the discoveries and, you know, the interlocutories. Let's just go with formal mediation. So they stopped that arbitration, and they applied to the ICC for a formal mediation process. The good news is that, this is the slide, that when you have already paid for an ICC arbitration at the administrative fees, you don't really have to pay another set of fees to do mediation. So a part of your ICC's administrative expenses that you've paid for arbitration, that gets set off by using formal mediation within the ICC. And likewise, if you first start an ICC mediation and you say, no, this is not really going well, I now need to do arbitration, then half of what you've paid, half of your admin expenses that you've paid to the ICC for your mediation get set off in arbitration. And just to give you an overview of the process of the mediation procedure, you start with a request, there's an official acknowledgement, parties' comments on the request for mediation, and then there's a preliminary deposit that the ICC takes to do for the administrative expenses. They appoint an arbitrator and transfer the file to the mediator. And the other procedure is, of course, you first you meet the mediator. There's a mediation note that is prepared. The mediation takes place following the life of the case and the termination of the case, and then you settle fix the fees and the costs of arbitration. Now, what you see here is actually statistics from the ICC Mediation Center. And of course, mediation is going to be less expensive than arbitration. And in terms of a timeline, right, I'm sure whether it's an ad hoc or an institutional arbitration, I can speak about ICC arbitration. And ICC arbitration, if all things go well, you can finish an ICC arbitration, no matter how complex it is, anywhere between 14 months to 24 months, right? If it's very complex, unless, of course, nobody is behaving erratically and nobody is being recalcitrant, 24 months, give or take, you can do it. But if you're doing a mediation, right, and you can have a $100 million dispute, a lot of construction disputes come out of, this part of the world, especially Sri Lanka, there's so much going on. Mediation has become quite popular in taking that first leap of faith in resolving your disputes. Not only in commercial arbitration. These days, actually, investor-state arbitrations, I think mediation is something that is being very seriously looked at. States are resorting and adhering to the formal process of mediation when they have disputes with the investors. And like I had said before, that there is a very good chance of a success rate of a settlement when the first meeting is held with the mediator, and it's about 80%. There are some statistics to suggest that it can go actually up to 80%. So all those who've not believed or not subscribed to the idea of mediation are highly encouraged to look at the process, the formal process of Med, Arb, Med. And of course, it controls over both the decision to settle and the terms of any settlement agreement. It preserves, obviously, good relationships between the parties because you're not being contentious with each other and not writing stinky letters in a formal arbitration or a litigation process. And most importantly, it still remains confidential, right? All proceedings by default at the ICC the proceedings that are conducted by the ICC are confidential, as are mediations. So that takes care of one of the pillars of, you know, DRS outside of the court systems. That is what I really had to give you an overview. I really don't have, I mean, I can go really deep into the topic, but unfortunately we don't have the luxury of time today, but I'll be very happy to take any questions that you may have about ARB, MedArb in the course of the day. Thank you so much.
Thank you very much, Mr. Bhushan. I'd like to ask you to please come back up on stage to receive a token of thanks. And alongside, I would also like to request Mr. Samir Jain to please join us on stage. For the presentation party, may I please invite the ICC Sri Lanka board members to please present tokens of appreciation to the two gentlemen. Thank you, gentlemen. Ladies and gentlemen, it is now time to hear from another diverse panel of speakers, bringing a wealth of expertise as we start this next panel discussion. To conduct this panel discussion, it is my pleasure to invite our moderator, Ms. Tahara Wijeratna, attorney at law, alongside the panelists present here with us today. Ladies and gentlemen, please recognize our esteemed panelists for today. Director of Foreign Law, Drew and Napier, Singapore, Mr. Abhinav Bhushan, President's Counsel, Mr. Harsha Fernando, PC, Chief Executive Officer of the Colombo Stock Exchange, Mr. Rajiv Bandadnaika, Acting Executive Director, Legal at the Board of Investment, Ms. Himali Urugodawatta, Vice President and Group Chief Legal Officer of Aitken Spence Corporate Services Private Limited, Mr. Navin Pereira, and the Assistant Director of Legal and Regulatory Affairs of Nestle Sri Lanka, Mr. Kirti Pathiraja. Joining us online from Cambodia, we have international consultant Dr. Jamel El Akra, and from Indonesia, we have arbitrator Professor Huala Adolf. Ladies and gentlemen, the stage is all yours.
Thank you very much. A warm welcome to our distinguished panelists. We will now move on to our second panel discussion, which is on commercial mediation, resolving disputes and preserving partnerships. This panel will explore commercial mediation as a vital alternative to traditional dispute resolution methods like litigation and arbitration. The discussion will center on how mediation not only helps resolve commercial disputes, but also preserves and strengthens long-term business relationships. We'll explore the strategic advantages of mediation, the critical role of the mediator, and the factors that influence the decision to choose mediation. A kind reminder to our distinguished panelists that you will have 4 minutes to answer the questions which will be directed to you. And as you can see, there is a timer on the screen. Once the timer runs out, I kindly ask you to please end with your concluding remarks, and so that we can quickly move on to the next speaker. Thank you. So let us now dive right into the questions. My first question would be over to you, Mr. Bhushan. In your view, how does mediation differ from arbitration in terms of cost, efficiency, and the and the preservation of business relationships, and under what circumstances would one be preferable over the other?
Thank you. So, a slight sort of a more deeper answer to what I was earlier alluding to. In terms of costs, you can look at the ICC cost calculator for costs in arbitration. So say you have a $10 million dispute, whether it's one arbitrator, three arbitrators, a $5 million dispute, or a $100 million dispute. On any metrics, mediation is going to be far less expensive, not just inexpensive. And I think it could be even 90% or 95% less expensive compared to an arbitration. In terms of efficiency, again, how do you really define efficiency? As Mr. Jain was mentioned before, efficiency is not always being fast, right? But again, on any metrics compared to an arbitration and the timelines that an arbitration takes, a mediation is going to be far more efficient, especially when it comes to timelines, right? You can actually finish, no matter how complicated the mediation is, within 3 months. I don't think that might be possible to do that in arbitration. And in terms of preserving relationships, right? So I drew an APA in Singapore, many arbitrations, and my day typically starts with writing very contentious and sometimes not so pleasant letters to the other side. And that continues through the cycle of the case, from the filing of the request for arbitration and telling the other side how badly drafted or how badly you presented your case, to really, bolstering your own case. In mediation, on the other hand, the process is more informal. The process is more, for lack of a better word, civil in that sense, right? I mean, you have a formal mediator, and I believe, Dato is here. I don't know, maybe he may have stepped out. There's a formal mediator who is really, what he's really trying to understand is the interests of both the parties, making them come to the same table, understanding what is it that they really want, and going through that process with them collectively, as opposed to an arbitrator who is the obligations of an arbitrator and the ethical duties of an arbitrator and the responsibilities and power of an arbitrator are quite different from that of a mediator. In terms of neutrality, independence, of course, there are some commonalities, but the process and the texture and the DNA of both these processes are quite different. And those who've been there and done that, and stories of family disputes, stories of not just, and within family disputes, property disputes and personal domestic disputes, there is a very high success rate compared to when you go through arbitration. And then after the arbitration, arbitration doesn't really stop when you get the award, right? The arbitration, you get the award, then you go for enforcement, the other side will resist enforcement, or you challenge the award at the seat court, and the other side will then come and resist the challenge. And then once that procedure of challenge and enforcement can take sometimes longer than the process of arbitration itself. And people in this room are, I'm sure, have experienced that at some point in time in arbitration, that when you calculate the cost of arbitration, you simply don't calculate the cost of arbitration from the request of arbitration till the award. The cost of arbitration continues for enforcement, and until such time you get your monies. I mean, the way I say it is that typically an arbitration should work like an ATM card, right? Your award. That now that you've done the New York Convention, you've gone through the process, you have now an award. You should typically take that award like your ATM card to the court and say, here is my award, please give me my money, right? And then the court would say, all right, this is a New York Convention award, please take the money, attach properties. So it doesn't happen like that, right? And then, of course, it comes down to which jurisdiction you're trying to do that in. I don't like the word friendly arbitration jurisdiction or unfriendly, but yes, of course, it depends largely on how the judges understand. So thank you.
That was a very loud bell. Okay. Thank you very much, Mr. Bhushan, for sharing those very interesting perspectives. I think a lot of people would probably leave here today changing their mind on as to why mediation may be the better form of dispute resolution in this case. Thank you. My next question over to President's Counsel, Mr. Harsha Fernando. Under what circumstances might parties opt to use arbitration and mediation interchangeably? And does this approach remain as effective as relying solely on mediation in preserving commercial partnerships?
Thank you, and it's a very good question. I think the answer I would start at the very beginning. One is the parties must take a strategic decision as to what mechanism they must use. Because courts, mediation, arbitration, negotiation, conciliation, those are the sort of the usual suspects available to you to resolve your disputes. So as to what forum you use is a strategic decision. And the strategic decision must be based on what I would call a little bit of conflict analysis. What is the nature of the conflict? And then find the forum that best suited to resolve that dispute. It's not a one-size-fits-all. So in that context, if you look at it, arbitration and mediation, in my view, are two very different mechanisms. Although we use them in the same light and sort of lump them together under the ADR title, they're very different mechanisms. And mediators and arbitrators need a very different skill set, and therefore, if you understand those dynamics, which we don't have time to go into, then yes, if you can actually use them interchangeably, strategically, I think the effectiveness is a lot more than using perhaps arbitration as a standalone mechanism. I strongly believe in mediation, so I would certainly say my first preference would always be for mediation, because if you think about it, even Mr. Bhushan mentioned about the costs. When you said arbitration costs, one thing that we forget is the relationship costs of a business deal gone bad. That's huge, and that never gets calculated in your arbitration listings. So therefore, if you look at how broadly you can define the conflict, analyze the conflict, the dynamics, and then decide on the forum. And while the process is going through, particularly arbitration, an arbitrator or the parties might come to the realization, okay, we have reached this stage, maybe we need a different dynamic. Maybe now it's time for us to subject ourselves to the dynamics of mediation and sort of get ourselves out of that sort of very adversarial approach that arbitration tends to take. But the question about using it interchangeably also has certain implications. I personally prefer mediation followed by arbitration, and not, mediation first, arbitration second, not the other way. Because once you file your arbitration claim and your answer, it's not very different to court. You become rather positional. And you define your issues rather narrowly. And some other areas that gives you the ability to resolve, like future contracts, future business arrangements, future value. Those things are not caught up in the way you articulate your dispute in arbitration proceeding, just like in court. So once you have articulated that and got the advice of lawyers who are very used to adversarial thinking, then within that framework, trying to get them to get the full benefit of a mediation technique might not necessarily yield the optimum results. But having said that, using them interchangeably has its benefits. ICC recognizes it. But again, I come back to the point I started with. It's understand the conflict, the nature of the conflict, and then take a strategic decision based on which forum is good. And today I can tell you now, last week we finished a commercial dispute. You said 3 months. It took me 1 year and 3 months. But the whole dispute was on relationship, finally when we analyzed it. But the value of the dispute was close to 4.2 billion rupees. But underlying cause was a very relationship issue which no arbitration or court would have caught up. Thank you.
Thank you. Thank you very much, sir. I think that was a really good answer, and thank you so much for sharing those perspectives with us on the interchangeability of arbitration and mediation. My next question is to you, Mr. Rajiv Bandaranaike. In your experience, how effective has commercial mediation been in maintaining long-term partnerships compared to other dispute resolution mechanisms?
Yeah, so let me draw from the experience of the stock exchange where we have a grievance handling procedure or a dispute resolution procedure. In that, we have at a base, when there is provision for stakeholders of the stock exchange to lodge complaints. For example, investor or a shareholder against a listed company, or an investor against a stockbroker, one stockbroker firm against another stockbroker. So we have a set of rules which govern this grievance procedure. At the base of it, it's mediation. So at the first instance, when there is, let's say for example, if we have an investor who has an issue with a particular stockbroker firm, and this investor fails to remedy it through the broking firm process of compliance officer, etc., then they bring it to the stock exchange, and we have at a base a mediation. We try to mediate. Then at the next level, if that fails, it goes to an independent panel, which is a grievance complaint handling procedure, and that panel is consisted of professionals independent of the stock exchange. We have lawyers, accountants, other professionals seated on it, and there's a committee of 3. Now the important thing is that the decision of that panel is enforceable, which means, for example, if a decision is given against a stockbroker firm and the stockbroker firm fails to comply, then there will be disciplinary action taken against the stockbroker firm. To that extent, the second tier is where a decision is enforceable. Now, in our experience, what we have found is for any given year, we have roughly, say, 10 to 12 complaints. When markets are up, there are no complaints, by the way. When markets are down, we have a lot of disputes coming into play. So any given year, that's about the number, 10 to 12 complaints. But in our experience, what we have really found is that, of course, we have heard a lot about mediation versus arbitration and litigation and the benefits of mediation. It promotes collaborative effort, more innovative outcomes. I think parties are more probably involved in the decision, etc. But having said that, our experience has been that mediation is not enforceable. So by the time it comes to us, parties are already not in the best of terms, etc. And they are wanting an enforceable decision. So at the base, we try to negotiate probably party successful. Maybe 50% of the cases, we are able to offer a settlement and mediate. But most of the parties would want some kind of outcome and an enforceable outcome. And because some of these cases, values are, I would not say very large, but probably in the range of, in rupee terms, between 50 million to 100 million rupee disputes, etc. So it's sizable. And therefore, I think they are looking for more enforceable decision. And as such, our experience has been, the outcomes have been mixed, but more tilted towards probably the second tier, where they are wanting a decision that is enforceable as against mediation. So that has been our experience.
Thank you very much, sir. I think it was very interesting to hear those perspectives from your experience at the Colombo Stock Exchange. Thank you so much. My next question would be to Dr. Jamel El Akra, who is joining us online. I hope you can hear me, sir.
Yeah, very well.
Great. My question to you is, given the ICC's emphasis on flexibility and party autonomy in its mediation rules, how can parties and mediators best leverage these rules to move beyond simple financial settlements and instead foster creative, business-focused solutions that truly preserve and strengthen long-term commercial partnerships?
Well, first of all, greetings to all participants and to my fellow colleagues in the panel. Thank you for having me at this conference, and especially I'm grateful to Mr. Shanil Fernando for the kind invitation to join this panel discussion, and I'm pleased to be here also in my capacity as the member of the International Advisory Council of the ICC Sri Lanka Arbitration and Mediation Hearing Center. So that's an interesting question. As other panelists have mentioned, commercial disputes in mediation are never one size fits all. Some are personal, Others are complex, cross-border corporate conflicts, for example. This diversity reflects today's business reality and does demand flexibility and creative solutions. That's where the ICC mediation rules can shine. They offer autonomy, adaptability, and the frameworks that turn conflict into opportunity. As the Honorable Justice Yasanta Koda said this morning, we need a paradigm shift. Mediation isn't just a tool to resolve disputes. It's a strategic lever to prevent them and unlock new possibilities. It's not about compromise, it's about also realignment and rebuilding. Consider this. Two global manufacturers and retail companies in dispute over delayed deliveries. Litigation would have ended their partnership. Instead, through a mediation, they restructured obligation, adjusted the timelines, and co-invested in a logistic hub. So conflict may become also an opportunity for collaboration. And that's the power of what I'll call strategic mediation. And the Article 7 of the ICC mediation rules, though a decade old, is still a game changer, I think, because it allows parties and mediators to co-design the process. It also opened the door to what I'm calling the multi-stage mediation, where urgent issues are tackled first and followed by deeper strategic discussion. Flexibility also extends to participation. Depending on the dispute, parties can involve legal counsel, technical experts, senior executives. And if we look at the ICC guidance note, for example, it even encouraged decision makers to be present because meaningful outcomes require meaningful engagement. Also, the mediator's role is crucial, not to decide, but to guide, especially in the facilitative model of mediation. And because mediation is a voluntary process where parties to a dispute are assisted by a neutral third party to negotiate a settlement, we can think of the mediator as an architect, helping parties to build solutions that truly reflect their needs. The outcome finally belongs to the parties. The mediator simply builds the bridge. So I will not repeat that, but mediation can also run alongside other ADR methods. It helps preserve relationships, narrow dispute, and support hybrid models, such as has been already said perfectly, Med-Arb or Arb-Med. But here it's about giving businesses the flexibility to choose what works best and what is the most appropriate. Sometimes you need to force the hand, though. Although I'm currently living in Cambodia, I've been appointed, for example, as a mediator by a judicial court in Paris under an injunction to meet a mediator in accordance with French law. And the mediation is being administered through the WIPO Arbitration and Mediation Center. So why not consider a similar approach for the ICC and domestic courts in other jurisdictions? Ultimately, ICC mediation isn't just about resolving what went wrong. It's about reimagining what could go right. By making ADR also more inclusive across mindsets and socio-economic backgrounds, we can unlock its full potential, I think. So let's move beyond seeing mediation as a last resort. Let's embrace it as a first step toward innovation, collaboration, and sustainable business relationship. As I see that my time is up now, I'm looking forward to meet you all in person in Sri Lanka in the upcoming months later this year, I hope. Thank you very much.
Thank you very much, Dr. El-Akra, for actually joining us online today and sharing your valuable insights. My next question goes to Ms. Himali Urugodavatta. In your experience with the Board of Investment, how critical do you believe the mediator's role as a facilitator in guiding parties towards constructive dialogue, and what skills or approaches make this role most effective in resolving disputes?
Thank you, Dara. If you take the BOI, Board of Investment, we, as our DG mentioned earlier, we have the dispute resolution clause as arbitration. But looking into it, I will go through the role. BOI is a facilitator, and also in the current world, business world, mediation is, we have to look into mediation as well. I'll go through why I feel we are also looking into having MEDAP dispute resolution clause, because commercial mediation, in commercial mediation, the role of mediator as a facilitator is absolutely vital. It's not just for resolving disputes, but for preserving long-term business relationship. Because for BOI, we have the investor BOI relationship, and we have to preserve even after a dispute. So we need to have a flexible procedure when we have with regard to mediation as well, because if you have a ad hoc, then the result will not be achieved. It is achieved, it can be, the mediator, the negotiated settlement can be achieved with the help of a neutral facilitator, as well as it's absolutely central to the whole process, the role of the mediator. The mediator's role as a facilitator is very essential. The mediator isn't, you have also to look at the principles of party autonomy, neutrality, confidentiality, and flexibility. And the mediator is the person who operationalizes these principles. Mediator doesn't take decisions, make decisions, or take sides. Instead, they guide the conversation, help both parties understand each other's perspective, and create a space where real dialogue can happen. And also, it's a process where a neutral third party, the mediator, assists the parties in settling their dispute. The word assist is the key. The mediator isn't there to judge or decide, but his role is to guide the conversation, help parties clarify their interest, and move towards a solution that works for both sides. Also, the mediator needs a specific set of skills. Impartiality is not non-negotiable. The mediator must disclose any circumstances that might affect their independence. This builds trust, and trust in the foundation of any productive dialogue. Next is flexibility. Flexibility has to be there. The mediator has to tailor the process to the needs of the parties. For example, selecting mediators based on language skills, experience, and availability. This means the mediator can be chosen to suit the commercial and cultural context of the dispute, which is especially important in international cases. And then the critical element is confidentiality. That gives parties the confidence to speak openly, knowing that what's said in mediation won't be used against them later. That openness which, is what allows the mediator to help parties move from questions to interest, and that's where real resolution happens. Then also the mediator should have active listening skill, empathy, and ability to manage emotions, and those are very essential. These help the mediator reframe issues, diffuse tension, and keep the conversation constructive. The strategic value of mediation in a commercial context, litigation and arbitration can resolve dispute, but often damage relationship. Mediation, on the other hand, is designed to preserve them. So to sum up, the mediator's role as a facilitator is not just procedural, it's strategic. They create space, guide the dialogue, help parties find common ground, and in doing so, they don't just resolve disputes, they help preserve partnership. And in the investment context, we are looking to introduce the mid-DAB or three-tiered, because at the end of the day, we have to preserve relationship going forward. going forward, and thank you.
Thank you. Thank you so much, Ms. Urgodawatta, for sharing your insights. My next question goes to Mr. Naveen Pereira. From an in-house counsel's perspective, what factors influence the decision to pursue mediation over litigation or arbitration in commercial disputes?
Yes, actually, I thanked Mr. Bhushan earlier as we got up on stage because thanks to him, he covered most of what I'm going to say. So thank you, Mr. Bhushan, again. Actually, from a in-house counsel's perspective, my thing is if we explore mediation, it would be cost effectiveness and basically time efficiency. Because we are a busy conglomerate and we need to move forward with our other commercial activities. So mediation is something that we could explore in time to come. But if we are to do that, something which has to be is the key point that we need to have a mediation clause in the contract. That is most essential. And then thereafter, I was at a seminar yesterday where the mediation clause and the arbitration clause and the interchange of that was being discussed. In actual fact, more than anything, more than having the, the written contract, it's more of a, for Sri Lanka, it's the mindset which has to be changed. Because we need to get used to that and, go into that sort of a dispute resolution mechanism in time to come. Like what was discussed in the previous panels earlier, it was discussed about, where we have a litigious mindset. And we need, it's something I think we need to evolve, we need to change over time, and we need to bring in mediation, arbitration as go-to areas of solving a dispute, which is going to be better. I'm not saying that, that is the thing, but it is an area which can be discussed. Now, earlier, mediation was practiced in a loose sort of manner. Now, it is becoming prevalent. And from what I know, there are companies which are using mediation as a tool to solve disputes. And also, I'm happy to say that Sri Lanka is a signatory to the Singapore Mediation Convention. So there is international backing for mediation as well. So I of course think that mediation is an area which we should explore. Thank you.
Thank you very much, Mr. Pereira. I can also relate to that previously working in-house where every time a dispute would come up, first thing they say is, take them to court, go to court, because that's, it's just the fact that, it's every time there's a dispute, that's what's being said. But it's nice, it's refreshing to see these new perspectives coming from an in-house counsel as well on how mediation. We do have to evolve. I 100% agree. Thank you so much. I would now like to direct my next question to Professor Huala Adolf, who is joining us online. Can you hear me, sir?
Yes, thank you.
Thank you. Sir, my question to you is, what is the single most valuable strategic advantage that mediation offers over litigation beyond just cost savings when the client's long-term commercial relationships are at stake?
Thank you, Madam Moderator. And first of all, I would like to thank Madam Natasha from Sri Lanka International Arbitration Center for inviting me as a member of this panelists. Mediation is a very important mechanism today for the resolution of dispute. Madam Moderator, could you please say it again, your questions?
Yes, of course. Of course, sir. So usually when we refer to mediation, what's constantly being said is that it's cost effective. So if I can ask you, other than cost effectiveness, what would be another advantage of mediation?
Yes. Mediation may be offering a lot of advantages to the disputants, to the parties in dispute. It is flexible. The rules are, it can be, the parties can change the rules, whatever rules they think that it is best for them. The problem with mediation is, like in arbitration, there is a saying that arbitration is good as arbitrator. So I also believe that mediation is as good as mediators. So the key for this, the effectiveness of mediations with regard to its advantages to the parties, is that the mediators has a big responsibility to the parties because the parties trust the mediators to solve their dispute. So this trust is a big responsibility on the shoulder of the mediators. My personal opinion is that if one must be, if he decides to be a mediator, then he must have certain qualifications that ordinary people do not have. A lot of advantages offered by mediation, but in the end of the day, it is the mediator skills, knowledge, and also yes, skills, communication skills, if psychological knowledge, and also the of course he must know the subject matter of the dispute. He must have better knowledge about the dispute and also the root of the issue, why the dispute arises. With all of these knowledge, skills, or psychological knowledge, and also the cultural sensitivity of to the parties, and I believe that all of the advantages of mediations that already said maybe come into reality. So mediation is important, yes, but the mediator is more important of all.
Okay.
That is the my reply to your questions, Madam Moderator. I hope that my response answer to your questions.
Yes,
Thank you.
yes, very much. Thank you very much, Professor, for joining us online today and sharing your insights. And my final question goes to you, Mr. Kirti Pathiraja. How do you, as in-house counsel of Nestle Sri Lanka, evaluate whether mediation will not only resolve a dispute, but also preserve the ongoing business relationship?
Thank you, Dara. The role of the in-house counsel is not being a litigator. My personal view is, when you are an in-house counsel, you should have the mindset of a businessman, at least for 70%, and balance 30% should be a lawyer. So in that context, we always incorporate environment, we always promote the winning mindset. But winning in a litigation may lose a long-term business partner. Now, there are many stakeholders in our value chain. It can be your suppliers, different service providers, distributors, your retailers, many. Today we call them as, all of them as business partners. We don't call them vendors, we don't call them suppliers, we don't call them distributors. Because this partnership drives the business forward. Because it's not always the contractual terms. There are instances, because as businesses, we go through many external challenges. There are stakeholders, they go beyond their contractual terms and support the continuity of the business. So in that type of environment, the value of the business relationship is very important, more than the strict contractual terms we have in the contract or in the transaction. And the sensitivity of our information, because we are in the FMCG industry. There are many business sensitive information we share with our stakeholders, our business partners. So we can't, it can be certain formulations, it can be certain margins, certain profit margins, transactional details, which we cannot discuss in a courtroom because it's a public document whenever you present it in the court as a piece of evidence. But in mediation, we can preserve the confidentiality. We can come to a win-win situation in our, because there can be disputes, because we all are humans. There can be disputes. But whenever there's a dispute, if mediation is available as the first option, we can come to a win-win situation, preserving the long-term business partnership, preserving all the confidentiality or the business sensitive information without going to the hands of the public. So that is why always the mediation should be, the commercial mediation should be an option wherever it is possible, because Nestle is operating in more than 185 countries in the world. I've seen in some countries even trademark disputes, unfair competition disputes were referred to mediation, and the solutions were also given in those disputes without going into to the extent of the litigation. Thank you.
Thank you very much, Mr. Pathiraja. I like how you use the term win-win, because I think that in itself defines what mediation truly is. It is a win-win method of dispute resolution. Thank you very much to our distinguished panelists. We now conclude this panel discussion on commercial mediation, preserving partnerships. Thank you so much.
Thank you very much, Tahara, and to our esteemed panelists for an insightful discussion. May I now kindly invite the board members of ICC Sri Lanka to join us on stage to present tokens of appreciation to our distinguished panelists. Thank you very much, ladies and gentlemen.
Ladies and gentlemen, here to present to us on the enforcement of arbitral awards, dual pathways and limitations of the passive remedy, let me warmly welcome Mr. Jeremiah Rise, partner of Stephen Thiru, Advocates and Solicitors, Malaysia. Welcome.
Hi, good afternoon, everyone. To the Right Honourable Judges of Sri Lanka, members of the Sri Lanka Bar, distinguished guests, I am Jeremiah Rice, and I'm a practitioner out of Stephen Thiru in Kuala Lumpur. But before I start, I would just like to extend my gratitude to ICC Sri Lanka, in particular Mr. Shanil Fernando, Chair of the ICC in Sri Lanka, and his team for inviting me to this beautiful country. It is indeed a privilege to be here, albeit slightly daunting to be speaking in front of such a distinguished audience. I'm also painfully aware and have been reminded that I have the post-lunch slot, so I'll do my best to ensure that everyone stays awake and I shall not interfere with your digestion. This afternoon, I'd just like to share some thoughts on the enforcement of international arbitration awards. In particular, I'll focus on two very recent Malaysian decisions, both of which I have to confess I had the privilege of being on the losing team. So the story comes from two decisions which were handed down just last month. The first is the decision of the Federal Court of Malaysia's Apex Court on the 13th of August, and the second was a decision that was delivered just a few days earlier on the 8th of August by the High Court between the same parties and arising out of the same facts. Now, before I proceed, I think I should set the factual basis for the two cases to give a bit of context as to the principles that were later decided by the two courts. So both cases arose, as I said, from a common factual matrix and dealt with two disputed bunker fuel transactions. OW Bunker was the purported supplier, ING Bank was the assignee of OWB, and Tumpuan Mega was the purported buyer. There were two disputed invoices incorporating a London arbitration clause, which arose from or by reference to OWB's standard terms. On that basis, ING and OWB commenced arbitration in London under English law. Now, in the arbitration, and this is crucial, Tumpuan raised two defenses which went to the very root of the UK tribunal's jurisdiction. First, it said that the disputed transactions were fictitious in that there were no genuine bunker fuel deliveries, and if that were true, the invoices were fabricated and there could be no English arbitration clause by way of incorporation. Now, the second alternative argument, which was raised late in the day in the UK arbitration, Tumpuan pointed to an agreement known as the set-off agreement, which provided for a Malaysian arbitration clause. According to Tumpuan in the arbitration, or the counsel in the arbitration, this displaced the English arbitration clause contained in the two invoices. The UK tribunal wasn't persuaded. It found that the deliveries had taken place, or at least that Tumpuan was stopped from arguing that they did not take place. Therefore, the invoices were valid, and the London arbitration clause was properly incorporated as to give it jurisdiction to determine the matter. Now, with regard to the second argument, the set-off agreement argument, the UK tribunal held that it was raised too late in the day, and Tumpuan was therefore barred by virtue of Section 73 of the UK Arbitration Act 1996. So then what transpired, if you look at the 2 points the last 2 points, an award was rendered in London. ING and OWB then obtained a confirmation judgment pursuant to Section 66 of the English Arbitration Act. And that confirmation or English confirmation judgment was then brought to Malaysia to be registered as a judgment of the Malaysian High Court under the Reciprocal Enforcement of Foreign Judgments Act, or REJA. Then what did Tumpuan do? Tumpuan, in the registration, the REJA proceedings, applied to set aside the UK judgment, or the registration of the UK judgment as a Malaysian judgment, and in parallel to that, also commence a fresh Malaysian arbitration on the basis that the pursuit of the UK arbitration was in breach of the Malaysian arbitration clause in the set-off agreement. Now, before we turn into what the Federal Court and the High Court actually decided in the 2 cases, we just need to take a step back to see what the model law actually provides for in these sort of circumstances. So, as I'm sure all of you are aware, there would be 2 ways to challenge an award or resist the enforcement of an award. The first being an active, or what they call the active remedy, where you apply to set aside the award at the seat, in this case in the UK, which never happened. And the second, a passive remedy, which is to resist recognition at the enforcement stage, i.e. in Malaysia. And the passive remedy is actually provided for, or at least illustrated, in 3 cases. The first case being the case of Dalla and the government of Pakistan that was decided by the UK Supreme Court. The second is PT First and Astro Nusantara by the Singaporean Court of Appeal. And the third, an Australian decision in IMC Aviation. These decisions confirm the existence of a passive remedy, and that when it is invoked to pursue a jurisdictional challenge, for example, in this case, that there was no proper incorporation, then the Malaysian court or the enforcement court can take a fresh look and retry the matter by calling fresh evidence, new witnesses, and pretty much put aside the principle of res judicata. The basis for this is that res judicata cannot arise in circumstances where the tribunal's jurisdiction itself is impugned. And now that is why the passive remedy is, or perhaps worse, very attractive. It would give an award debtor or the losing party a second bite at the cherry to challenge jurisdiction and reopen the issue of jurisdiction afresh by calling fresh evidence and witnesses that may very well have not been called in the arbitration. Now, jumping as to what transpired in the federal court, a point of contention in the federal court was the question was whether there were 2 means of enforcing an award. The first, direct enforcement, or your typical model law route, where you take your award and then go by way of Article 35, or in the Malaysian context, Section 37, by registering it as a judgment of the Malaysian court, or do what ING and OWB did in our case, by indirectly enforcing it, in the sense that you have an award, and in the seat, obtain a confirmation judgment in the seat, and then take that confirmation judgment and register it under general reciprocal enforcement legislation. No, so now the question is, why does it matter? Why does the choice of enforcement matter? It was argued because the choice shapes the fight. If an award was directly enforced, the award debtor, in our case Tumpuan Mega, should be entitled to exhaust the full menu of grounds to resist enforcement under Article 36 of the model law, which has been incorporated by virtue of Section 39 of our Act. And if the challenge goes towards jurisdiction of the tribunal, we should be entitled to a retrial and call fresh witnesses. On the converse, if an award creditor, as in this case, goes for indirect enforcement, the debtor's grounds to challenge or resist enforcement are much narrower, So challenges are confined to the typical reciprocal enforcement of judgment grounds, fraud, jurisdiction. But the more important thing is that there are a series of decisions of the Malaysian courts that even if you're challenging on fraud or jurisdiction, it's on limited curial intervention out of respect for committee and reciprocity. So the choice of pathway really shaped the scope of resistance that one would be entitled to in resisting an international arbitration award. Now, let's just quickly turn to what the federal court decided. It's a fairly lengthy grounds, I think close to 50 pages, but it can really be boiled down to 3 important points. The first, dual pathways are valid. Creditors can directly enforce under the model law route or indirectly under the reciprocal enforcement of judgment, and they relied on certain cases from US, including the case of sea transport, where the courts, they recognize what is termed as the parallel entitlement regime. Long and short, the court said, notwithstanding Article 5 for the model law or Section 8 of our Malaysian Act, neither legislation cancels out the other. The second it held was that the passive remedy does indeed exist in Malaysia. If you don't set aside an award at a seat, you can still resist enforcement as per the cases of Dala and PT First and IMC Aviation. But I think the most crucial point that the federal court held was that the scope of defense nevertheless depends on the pathway chosen. If the enforcement is under the Arbitration Act, Section 38, you resist under Section 39, then you are entitled to your Dala-style retrial or de novo hearings. But if you go by way of reciprocal enforcement of judgments, then the court actually held that there should be no roving scrutiny or reanalysis of factual matters pertaining to fraud. What the federal court did instead was to formulate a novel test, which is called the functional and materiality test, which requires the registering court to consider several questions, including, was the fraud likely to have changed the result? In our case, we said yes. 2, was there a realistic opportunity to uncover or challenge in the foreign proceeding? The federal court answered yes, there was, because you could have set it aside in the UK. Is the foreign system capable of addressing this type of fraud? That too was answered in the affirmative because of the availability of a regime under English law. And 4, would enforcement contravene Malaysia's public policy sensitivities? That was left for the High Court to decide because it's been remitted back down to the High Court. So long and short is that, sorry, just before I go there, the practical difficulty of this test is really the second and third limbs. If the seat, as the federal court answered here in this case, had mechanisms to deal with fraud and you didn't utilize them, you may very well fail the test in Malaysia. But the practical effect of it is that resistance in the enforcement court under REJA, even on jurisdictional grounds, is very, very limited. Okay? Now, just turning quickly to the High Court decision, a few days earlier, the High Court had decided on a related matter, and this is where Tumpuan actually tried a different tactic. And instead of waiting for enforcement under the model law, which of course never happened because it was pursued under REJA, Tumpuan began or commenced the arbitration under the set-off agreement, and as I said, on the basis that the pursuit, commencement, and the rendering of the award in the UK tribunal was in breach of the Malaysian arbitration clause. Of course, the Malaysian tribunal then dismissed it, said the parties were bound, parties are caught by res judicata, we can't undo what the UK arbitration held. Tumpuan then went to the High Court, but the High Court dismissed the challenge, or rather the application to set aside the Malaysian award. It held 2 key points. It's a lengthy decision. I've left the citation in my earlier slides, but 2 key points were made by the High Court. It's agreed that the passive remedy does exist, but passive means exactly that. You wait for enforcement and resist at that stage. You don't launch, or you don't be active and launch an arbitration of your own to challenge jurisdiction. So the High Court closed that door firmly. So what does this mean in practice? For award creditors, you now have, or at least in Malaysia, we're following US-style jurisprudence, you now have a genuine choice of pathways, either under the model law route or general reciprocal enforcement legislation. The first, under Section 38, your Arbitration Act route, is more orthodox, but it gives the award debtor much broader grounds to reopen certain issues such as jurisdiction. Now, with the Reja route, as I've said and explained, it's much narrower and is only available in reciprocating countries with Malaysia. And this is important, I think, because Malaysia recognizes Sri Lanka as a reciprocating country. What does it mean for award debtors then? You need to decide early. Do you go active at the seat and apply to set aside? And if you choose to go active, you need to be aware of timelines. You must be quick in applying to set aside. Or do you choose to rely on a passive remedy? Yes, the Malaysian Federal Court has determined that it does exist, but it is risky. If the award is indirectly enforced, you may be deprived of a de novo hearing, even if it relates to questions of jurisdiction or matters that go to the very root of the arbitral tribunal's powers. And there was one clear red line by the Malaysian High Court, is that you cannot create your own arbitration to attack the jurisdiction or indirectly attack the jurisdiction of a prior arbitral tribunal. So the key takeaway is really that the passive remedy exists, but it is defensive only, and its effectiveness and utility really depends on the pathway that the award creditor chooses. So just to conclude, in terms of the practical effects of these two judgments, if any of you being Sri Lankan, acting for Sri Lankan entity against a Malaysian entity, arbitrate under the ICC, get an award, and register it under Reja. Don't do it under model law, because that will severely restrict the basis or grounds to challenge the award. Unless there are any questions, this is my presentation. Thank you.
Thank you very much, Mr. Rice, for sharing your insights and for flying to Colombo just to be here with us today. It really means a lot to us. I would like to invite our chairman, Mr. Shanil Fernando, and members of the ICC Sri Lanka board to please present the token of appreciation to Mr. Jeremiah Rise. Yes. Thank you very much. Ladies and gentlemen, it is now time to hear from another diverse panel of speakers, bringing a wealth of expertise for the next panel discussion. To conduct this panel discussion, it is my pleasure to invite once again our moderator, Ms. Dhami Fonseca, attorney at law, along with the panelists present here with us today. I wish to invite Honorable Judge of the Supreme Court of Sri Lanka, Justice Dilip Nawaz, President's Counsel, Dr. Harsha Cabral, President's Counsel, Dr. Shivaji Felix, President's Counsel, Mr. Prashantalal Dialvis, President's Counsel, Mrs. Chamantha Unambua, and the Managing Partner, PSL Advocates and Solicitors of India, Mr. Samir Jain, and Partner, Stephen Thiru Advocates and Solicitors, Malaysia, Mr. Jeremiah Rise. Joining us online from India we have advocate Mr. Anand Majmudar and partner of Azman Davidson and Co. Malaysia, Mr. Rajendra Navaratnam. Over to you, Dahami.
Ladies and gentlemen, I'll now be moderating our next panel discussion on practical considerations and key factors when drafting the dispute resolution clause, a topic that lies at the very heart of effective contracts and successful dispute management. So just to give you a little bit of context, as you all know, dispute resolution clauses are often treated as boilerplate provisions in contracts, yet in practice, they carry a quite significant consequence for the efficiency, the cost, and enforceability of dispute settlement. A well-crafted clause provides clarity, minimizes procedural uncertainty, and safeguards the enforceability of awards or judgments across jurisdictions. So this panel today will explore the essential factors and practical considerations that contracting parties, counsels, and arbitrators must take into account when drafting proper dispute resolution clauses. So before we begin, I'd also like to take this moment to give you all the same kind reminder about the time constraints. In the interest of time for each panelist to please keep your response confined to 4 minutes. Thank you very much for your cooperation in advance. And also we may be having a Q&A session after all the panel discussions are over, again depending on time. So let's begin our panel discussion. My first question is directed at Honorable Justice Dilip Nawaz. What common pitfalls do you observe in poorly drafted dispute resolution clauses, and how do these shortcomings affect the efficiency of court or arbitral proceedings?
Thank you very much, but 4 minutes is not enough, I must say. But I must say this, sometimes it's so inscrutable, certain things happen by chance. Certain things happen coincidentally. As if on Providence, I had to tackle a question today. I was sitting in court, and exactly a case on this very same point that you are raising came up before us this morning. And since we have concluded the matter, and then since I virtually disposed of the matter off the bench today, I can discuss it. That will set the scene for this matter to be taken further. There was a loan agreement. In the loan agreement, the parties had specified the regular courts as the forum for the dispute settlement. In other words, if a dispute arises between the creditor who has given the loan and the borrower who had received the funds, they will go to courts. That's somewhere there in the main loan agreement. As an addendum to the loan agreement, there was this arbitration agreement. As arbitration agreement are severable, maybe they kept it in mind and they had it as a separate addendum. In that arbitration agreement, the clause was stark, facing you quite starkly. It said, in the event of any dispute between us, the matter shall be referred to arbitration. Now see the problems that it causes. These are called, I would say, pathological clauses. There is pathology attached to it. Now, today, a clever lawyer, a young chap, argued his client was taken to arbitration, not courts. He went and settled the whole dispute there. He entered into a settlement award. When the matter came up for enforcement before the Commercial High Court, an argument was taken, an objection was taken, the passive objection was taken, the arbitration agreement was void, and therefore you can't settle this. My settlement agreement is void, null and void. That was the argument. The Commercial High Court judge rejected it, and then it came up by way of an appeal. How do we deal with that situation? This is poor drafting. Now, as the chairperson said, when you draft your arbitration clauses, it must be done so with clarity. If you provide for a combined dispute resolution, as we saw today, that leads to all these arguments. What do the parties do? They end up arguing the arbitration clause is invalid, arbitration clause is ineffective, and the arbitration can't proceed. That's at the threshold. But once the arbitration agreement has borne fruition, resulting in an award, you try to set aside the award on the basis of the invalidity because how do we deal with this situation? Now, different jurisdictions have dealt with it differently. Today, we had to deal with it. So, we took the view, now that you resorted to arbitration, you settled it there, your intention to arbitration is irreversible. And there was this binding effect of that arbitral clause, despite the fact you put in the arbitration in the loan agreement a recourse to courts. This is the view that we took today. We had, fortunately, I was getting ready for this conference, and then I found certain case law on this, and the case law is to the effect that when there are conflicting drafting errors in this manner, you can give effect to the arbitration. This is called the rescue operations done by courts. We have done that in the past. There is a famous case in Sri Lanka, a case of LG Tread versus Bino Tires. The Supreme Court encountered a situation of a similar nature. The parties had said, poor drafting, I must say, parties had said, this dispute shall be referred to Sri Lanka Chamber of Commerce. There is no Sri Lanka Chamber of Commerce in this country. There is ICC here. It was argued in the Commercial High Court, since there is no proper and valid arbitration agreement, this matter must be tried in courts. Objection was taken. Court held otherwise. The matter came all the way to the Supreme Court. The Supreme Court finally did the same rescue operation that we did today. We gave effect to the Supreme Court in that case, a famous case, LG Tread versus Bino Tires, gave effect to the arbitral clause. In other words, you have the intention to arbitrate, even though you refer to a non-existent institution, your intention is to go for arbitration. So therefore, your error has to be ignored, and the parties must go for arbitration. That is how the Supreme Court held. It's all because this legislation that we have today, an antiquated, an old law that needs a lot of revisions. Arbitration Act number 11 of 1995 is modeled on UNCITRAL, and the UNCITRAL rules revised periodically have this cardinal principle that you must refer parties to arbitration unless there is some clear intention not to go for arbitration. So the Supreme Court did that in that case, and we did it today. So there are pitfalls that the lawyers have to avoid this. You may have to skip and exercise a lot of caution in drafting your arbitral clauses. These are my views. There are other things that I may wish to talk. One last point is, I would say recently there was an arbitral clause that specified interest. Interest could be claimed. but the seat was in Saudi Arabia. When you seat the arbitration in Saudi Arabia, but when you specify interest can be claimed by parties, it's a pathological clause. It's a defective clause. Parties argued there is no proper arbitration agreement. So this cardinal sin of drafting it poorly leaves a lot of contentious matters to be taken up, and it leaves this option to parties to argue there is no proper arbitration agreement, and therefore arbitration can't proceed. So we have to, we can't err on the side of the validity of arbitral clauses. It has to be dinned into lawyers. It has to be, it is very appropriate that we deal with this today. Thank you.
Thank you very much, Mr. Nawaz, for that illustrative example, and not to mention the very real-world situation of how it was handled from someone as experienced as you. My next question goes out to Mr. Samir Jain. What are the most common pitfalls when choosing the seat of arbitration, and how can these be potentially avoided?
Thank you for the question, and I think it's a natural corollary to Chip's answer on pathological clauses. So seat of arbitration is also called the home of arbitration. Why the home of arbitration is because the seat determines the process, procedure, and the challenge and everything relating to and surrounding the arbitration. And it's extremely important that we pay a lot of attention to the seat we are choosing, because the procedural law of arbitration will determine a lot of complex things. For example, in a lot of jurisdiction, the principles for taking evidence is considered the law and procedure. So it's important for parties to realize the seat that they are choosing, what are the laws of evidence and the process of taking evidence in that jurisdiction. Singapore, for example, is dealing with a situation where an Indian party chose Singapore as a seat of arbitration, and it was a shareholders agreement. And a dispute arose in respect of the shareholders in the company, which under Indian law would be the jurisdiction of the National Company Law Tribunal. However, the Singapore law allows shareholder disputes to be determined in an arbitration. Now, the question which is before the court is that whether such determination of dispute by an arbitral tribunal, which otherwise would go to the national courts and specialized tribunal, is a valid situation or not. So to avoid all of this, it's extremely important that a good seat is chosen. Now, in that regard, the CIRP came out with the London Principles, and there's Queen Mary study. Essentially, if we were to zero down on a couple of points as to what constitutes a good seat, I think the first and the foremost consideration is impartial and upright judiciary. While the whole process of arbitration is to take parties away from the courts, ultimately what makes a seat a good seat is how the judiciary in that seat is. Because the challenges will go to that seat, the interim relief, the parties may approach the courts, everything surrounding the arbitration, or any question which needs to be taken will have to be done by the courts of that seat. Second, whether that seat is signatory to the international conventions and treaties. Now, if there is valid recognition and signatory to the international convention on recognition of awards, then it's extremely important to take that into consideration. Also, from your country's perspective, it becomes important, or from the party's perspective, it becomes important whether the place where an award needs to be enforced, the country where the award needs to be enforced, and the country where the seat is, are the reciprocating jurisdictions or not. You don't want a situation where you get an award from a seat where there is no reciprocity, in which case you will be left with an award which cannot be enforced in your country. Third, is that seat safe, and is that seat easily accessible? There are situations where arbitrators have been threatened. There are cases where there have been parties have made threats to the arbitrators. So we really need to see whether the jurisdiction you are choosing as the seat is a safe seat. And when you combine all these factors, in my view, that these considerations must be taken at the time of drafting of the arbitration clause, and that constitutes a good seat for an arbitration.
Thank you very much for such a wholesome answer, both substantive and theoretical. My next question I would like to direct at Dr. Harsha Cabral. Dr. Cabral, when drafting a multi-tier dispute resolution clause, what practical challenges should be anticipated?
Well, thank you for that question. I think taking from the two earlier speakers, I think whether it's a multi-tier arbitration clause or a normal clause or whatever, a couple of things have to be taken into consideration. Pre-agreement stage. Now the pitfall is most of these the people go and enter into contracts, even big companies go and enter into contracts without looking at the consequences. So what happens is when they get into hot waters, only they run to lawyers and law firms, and then by some lawyers you are taken to the cleaners. So the issue is at the pre-agreement stage, pre-contract stage, before entering into the agreement, you must decide, okay, what are the best ways we can resolve this dispute? So, alternate dispute resolution mechanism comes into play when that question arises. You will have to decide, you have to go and get a sort of a overview of the subject from a person who understands that, and what ADR means, what is negotiation, what is conciliation, what is mediation, and what is commercial arbitration. So with that in mind, then you decide, okay, whether it's better to go to courts or to go to arbitration. Now, there was a time where people in Sri Lanka removed the arbitration clauses and decided to go to courts after the Commercial High Court came into operation, because from there it's just one step to the Supreme Court. So the arbitration clause, this is the dispute resolution clause, must be full of clarity, as the earlier speakers also mentioned. You must have first decide, okay, whether it's going to be an institutional arbitration clause or an ad hoc clause. I would always advise an institutional clause. For him, I've been ICC sitting arbitration in the ICC Court of Arbitration in Paris for 6 years as a sitting arbitrator, sitting member of the Court of Arbitration. I would always propose ICC, because ICC is internationally famous and comprehensive clauses are there. Anyone can log into the network and see how exactly it works, so that the client knows, okay, if I go to arbitration, if I have a proper institutional arbitration clause which says, okay, ICC, then you know from start to finish how much you will have to spend. The ability of your purse is important. How much you can spend, where you can spend that, and so on and so forth. So you get a rough idea of the expenses involved in the arbitration from start to finish. Depending on the size of the arbitration, you get a somewhat idea with regard to the cost factor. That is number one. Because I know in international arbitrations, people who have done international arbitrations would know, very often arbitrations, international arbitrations collapse. This has happened to certain countries where halfway through they realize that they can't afford the arbitration. Sometimes even not only the institutional costs, but the lawyer's fees alone. So you have to first know whether you can afford it. Then you must have a wholesome arbitration clause. The dispute resolution clause will be, you have decided, okay, this is the institutional arbitration. I always say ICC, because in these areas you have a lot of competition with SIAC, Singapore International Arbitration Center, Malaysian Asian International Arbitration Center, Hong Kong International Arbitration Center, DIAC, Dubai International Arbitration Center, let alone London Court of International Arbitration, ICC, and the others. So ICC is all over. So you decide for yourself, okay, this is the best, and you select the clause from there. That clause should be very, very clear to all parties. What is the language? What is the seat of arbitration? So then you decide on the substantive law and the procedural law. These things are very important before you go into arbitration. Not at the point when you have a dispute to decide those things. So beforehand you know if there is a problem. This is where we will have the arbitration. This is where we will sit for the arbitration. Seat of arbitration is known. This is the procedural law that will apply. If it's Sri Lanka, we have the Arbitration Act number 11 of 1995. Then the substantive law of the subject matter, that is very important, as he just suggested, that the dispute, Justice Nawaz mentioned about the interest matter. So those are the crucial matters to be thought of before entering into the agreement. So your dispute resolution clause should be clear to both parties, understood by both parties, and whether it's a 2-tier, 3-tier, or a simple dispute, I believe the clarity and the proper advice at the correct time is important. So once that is done, well, you get a head start.
Thank you very much, Dr. Cabral, for that answer. My next question goes out to Mr. Prashantalal Dialbis, PC. Mr. Dialbis, is it possible to maintain a standard dispute resolution clause regardless of the nature of the contract?
It is difficult, but I wish to state, because I come from a background more than a lawyer now, a corporate director, I'll take that view here, because I was a director of a bank, like Chairman Dr. Harsha Kabra, who is a chairman of a bank. So I'll take the financial sector as example and take this issue. Now in the finance, bank is a very hierarchical structure. But if you take the finance companies of Sri Lanka, for that matter, any part of the world, it is very aggressive. The marketeers go to the customer and canvas business. So in that kind of a context, it is very critical that these are not huge amounts that we are talking of international arbitration. In a Sri Lankan context, this kind of financial scenarios, it is very critical and important for us to understand that there is a mediation board which covers up to 1 million. And now we have small claim code which goes up to 2 million, where you can go to courts and get your relief faster. So those are the factors that we need to look at in that kind of a context. As an arbitrator, I have realized when you speak of this context of a smaller amount and we go to arbitration, it is in that context, the cost of the arbitration is more higher than actually the money to be recovered. And therefore, finally, it ends up nowhere, sir. So it is a much more burden on the client. So if you are selecting arbitrator in that kind of a sense, when I was arbitrator earlier, I was very keen to give an award. But later I realized that will not carry anyone any further. So I changed from an arbitrator who gives an award to a scenario of practical sense of negotiating. So these are the factors that we need to consider, especially when you have, these are the, unlike very sophisticated, complex arbitration that my learned friends referred to, these scenarios of financial sector affects the economy, affects the people, and therefore there are so many practical factors, especially the cost factors, that one need to look at if you are deciding on that kind of a scenario.
Thank you very much, Mr. Dialbis, for that practical answer. I'd like to direct my next question at Dr. Shivaji Felix, PC. Dr. Felix, given the complexity of tax-related disputes, what considerations should parties keep in mind when drafting arbitration clauses to ensure enforceability and also alignment with tax authorities or regulatory frameworks?
Thank you very much. Now, when it comes to taxation, it's a very complex thing, and it covers two broad categories, that is direct tax and indirect tax. When it comes to direct tax like income tax, there is nothing much that you can do because you have to comply with the law, whatever agreement, arbitration agreement is there, it is irrelevant because you have to pay the relevant tax as prescribed according to the applicable law. But when it comes to indirect tax, like for example value-added tax, then the situation is different. Because if you have an arbitration clause which requires a party to recover the relevant tax, as value-added tax for example, then you have to be careful that once you decide that the applicable law is prescribed, that is, the rates can change during that period, you have to collect the correct amount. And the most important thing is that at the time that it is payable, the invoice must be issued. Otherwise, 6 months later, when you are trying to recover a payment because the party has not paid, and the VAT invoice has not been issued, then there is nothing you can do. So it is very important that when you can have the agreement, the arbitration clause can have conditions, but you have to comply with the law in raising that invoice at the correct time. And more importantly, that you pay the amount to the Indian revenue at the relevant time. Because otherwise, if you have not paid that amount, you can't recover it from the other party. So that is a crucial aspect in value-added tax, and that has to be observed. There is also a hybrid area called SSCL, which is also relevant because there also you can recover part of it. But there, your agreement must have provisions for that recovery. And there also, you'd have to take steps to recover it at the relevant time. So those are important aspects, the indirect taxes, which have to be covered in an agreement. But the direct tax, of course, there's nothing much you can do because whatever you agree, if the law is decided otherwise, then that is the applicable principle. So those are some of
Thank you very much, Dr. Felix. Thank you very much for covering both the different types of tax and also the timings in which the payment must be duly made. I'd like to ask the next question from Mr. Jeremiah Rice. Mr. Rice, how can parties practically avoid conflicts between multiple arbitration clauses incorporated from different contractual documents, particularly where standard terms are involved?
Thank you for the question. So I think my fellow panelists have gone at lengths on clarity of arbitration clauses, and that certainly should be at the forefront when incorporating your dispute resolution clauses. But I think one often overlooked aspect of drafting that affects the dispute resolution clause is what is the agreement actually for? What is the master agreement actually for? Now, forgive me for going back to the case I spoke about earlier, but one of the nuances in Tumpuan Megah that I did not speak about earlier was that the set-off agreement in that case vaguely referred to the delivery and taking of delivery of bunker fuels. But what was explicit, it was that there were debts between Tumpuan and OW bunkers, and this agreement is for the set-off of such debts without stating explicitly how did those debts arise. And that actually gave room to the English tribunal to say that, you know, even if Section 73 doesn't apply, these transactions fall outside the scope, these purported bunker deliveries fall outside the scope of the set-off agreement. So I think the purpose of your master agreement, especially when you have a series of continuing commercial transactions that go from time to time, and you have supplementary agreements, etc., your master agreement must be very clear as to what its subject matter is, so that your dispute resolution clause can then capture all these subservient transactions. Now, the second point that I would like to make in respect of drafting dispute resolution clauses, or the practical aspects of it, is ensure the consistency across documents. So again, as in this case, you've got a master agreement, and then invoices which alluded to or referred to other standard terms which incorporated a conflicting arbitration clause. I think this is easier said than done, but it needs to be done, at least in a Malaysian context with the recent decision. But the practical implication is really difficult because there are invoices that may be issued and which may not necessarily go through the eyes of in-house counsel. Commercial guys usually deal with invoices, but there may be terms, innocuous terms, which ends up detracting from what parties actually agree to. So I think putting in place systems to ensure consistency between all transactional documents is essential if you want to avoid jurisdictional challenges or cases where you have two conflicting arbitration clauses that provide for two different seats or centers. The third point that I'd like to make is, if all else fails, your systems fail and there's some sort of conflict between your arbitration clauses, go for utilize tools such as your anti-arbitration injunctions. There was a recent Malaysian case as well in the High Court in respect of sanctioned fuel, where arbitration was commenced under LMAA in London. It was, I think the case is Black Swan, Petroleum DMCC, and Euronav Shipping. And what happened there was that there were conflicting decisions. London Tribunal was constituted, and an anti-arbitration injunction was applied for in the Malaysian High Court. And because of the conflicting decisions, the Malaysian High Court actually granted the injunction, prohibiting the English tribunal from proceeding with the arbitration. I think you should exhaust all possible steps early on. Don't wait and go to the very tribunal that you seek to impugn to raise all these points. I think as a matter of practicality, always try to exhaust it in the courts that you say has the valid arbitration. So just to sum it up, 3 points. It's clarity in your master agreements, especially where they entail supplementary agreements. Consistency across all transactional documents, and utilize tools in court such as your anti-arbitration injunctions. Thank you.
Thank you very much, Mr. Rice, for those 3 key takeaways. My next question I'd like to direct at Ms. Chamantha Unambua. Ms. Unambua, what key factors do you think parties should parties evaluate at the contract negotiation stage before deciding on the dispute resolution mechanism that they would adopt?
Thank you. I would say that the dispute resolution mechanism is about the aspect that the contracting parties themselves are least concerned with at the stage of negotiating the contract. They don't think or foresee the dispute. So it's left to the lawyers. It's the duty of the lawyers to look into that aspect, to consider that aspect, and bring the attention of the contracting parties themselves to that aspect. Now, if that is done, then these issues which His Lordship Justice Navas faced in court, those issues may not have come up. So therefore, now there are certain key factors. That is your question. One would be the nature of the contract. Now you have to see, the lawyers and the parties would have to see what kind of contract is it. Much would depend on that, whether they should go for mediation, arbitration, or litigation, and other factors which are relevant to choosing the method. So the nature of the contract would mean, like, is it a construction contract? Is it a technical licensing, technology licensing contract? Then, or is it joint venture, international joint venture? Then, or is it a local domestic supplies contract? So now if it is a joint venture, international joint venture, then of course different considerations would apply in choosing how to adopt a dispute resolution clause. It would be, now if it's an ongoing partnership, business partnership, then you would recommend a multi-tiered dispute resolution mechanism. You would first, because you wouldn't want to damage your relationship and cause a kind of a permanent damage. So you would go for these discussions, the mediation, then arbitration or litigation. In fact, the UK courts had upheld a clause which stated that there should be 4 weeks of friendly discussions prior to arbitration. So those things should be gone into, those aspects should be gone into. Then the enforceability of the outcomes. Now, I would consider that is the most important aspect, because you go along with an arbitration or mediation, and finally, if you cannot enforce the award, then there is no point in what you have done. So there we come to the choice of the seat of arbitration, as a speaker before me mentioned. That is extremely important. So that should be considered. So in considering the seat, as the speaker said, neutrality, the impartiality, all those matters have to be considered, and these are matters for the lawyers. It is the lawyers who should bring it to the notice of the contracting parties. So then the confidentiality, certain contracts which would require a great amount of confidentiality. Now there again, you can't go into litigation. Arbitration is a better, mediation or arbitration is a better option. So likewise, there are these factors which have to be gone into and which are really not gone into adequately. In fact, there is currently an arbitration where both parties are Sri Lankan companies, but somehow the arbitration clause contains a requirement that one arbitrator should be a foreign national. And that is not an arbitration which concerns a high value. So the expense on that is totally unrealistic. So these are matters which should be considered. In my view, they are matters for the lawyers to take up, explain to the contracting parties. My time is up, so thank you.
Thank you very much, Ms. Sunambo. It certainly brought light as to what parties should consider before going on to which type of dispute resolution mechanism they should opt for. My next question goes out to someone joining us online, an esteemed panelist, Mr. Anand Majmudar. Do we have? Yes. this question goes out to you, Mr. Majmudar. Are there sector-specific considerations, example, when it comes to construction, energy, finance sectors, that should shape how clauses are drafted?
Okay, so good afternoon to you all. See, the simple answer is yes. Arbitration clauses are not one-size-fits-all type of clauses. Different sectors such as construction, energy, finance, technology, and shipping have unique regulatory, commercial, and practical realities. Am I audible?
Yes, yes, you are.
Okay, thank you. Okay, so considering all these, realities in mind, one has to customize the clause very, very carefully. See, although it is known as a boilerplate clause, it has to be tailor-made and it has to be tailored considering the requirements, the unique requirements of the subject matter of the agreement. See, the essential to customize the clauses is to ensure that the relevant and effective provisions for specific contract and situation in hand are addressed. Now, if I may elaborate, the requirement to customize, keeping in mind the sector. See, to begin with, construction infrastructure. In case of construction contracts, generally the disputes are between parties, multi-party contracts involving EPC contractors, subcontractors, government agencies at times, etc. These clauses must be tailored, keeping in mind the nature of dispute, the parties involved, and it has to be flexible enough to allow joinder of parties, consolidation of claims and disputes. Now, this is the unique requirement, unique feature, which is very relevant, very important so far as the construction contracts are concerned. The seat and governing law, of course, I think much has been discussed about it, very important. But in case of public projects, in infrastructure construction, they may require, selection of a local seat, local governing law, and enforceability and compliance with public procurement laws. Technical expertise is again a very important consideration that we must keep in mind. While selecting the technical expertise, we have to choose DIAC or SIAC or ICC so that, proper technical support is available and the proceedings are adjudged in the most efficient manner. In case of disputes arising out of energy, oil, gas, and power projects, these are the contracts which are generally long-term contracts. These contracts involve the price adjustment mechanism, force majeure clauses, change in law. So, considering the variety of provisions under such contracts, it is recommended that we customize the contract arbitration agreement in such a fashion that all these unique requirements of the transaction are properly addressed. Now, provisions relating to performance of obligations during the arbitration proceedings. This is one of the most important provision, because what happens is that as and when the dispute arises, the performance normally may be hampered. The parties may stop performing their obligations. A suitable provision is necessary especially in energy contracts, oil and gas contracts, so that the performance is not hampered, the performance is ongoing, and suitable provisions must be incorporated within the contract provision, and the performance must go on, because the contract is long term. Arbitration is also a long term dispute resolution mechanism. Now, when we provide for the performance, we should also provide for resolution before arbitration, mediation, and expert determination. In any of the contracts, if there is involvement of foreign investment, then we have to also consider bids and investment treaties, and most importantly, fork in the road. These provisions must be incorporated so that parties are put, when there are multi-party contracts, parties are put to an election and they have to pick and choose one of the jurisdiction, and the parties will then be bound by that jurisdiction and that governing law. Now, specialized institutions like ICC, LCIA, SIAC must be involved so that the cross-border energy disputes are resolved effectively. Talking about finance, banking, insurance disputes, the arbitrability. See, in finance, banking, and insurance, all these three subjects also have local impact of local law. In this situation, we must make sure that the dispute remains arbitrable. It is not in contravention of the local laws. So in India, there are certain jurisdictions, and similarly in many other jurisdictions, there are certain disputes which are classified as non-arbitrable disputes. So enough care must be taken while drafting arbitration agreement, and non-arbitrable matters must be excluded. Default provisions must be considered, and we have to provide capture provision in such a fashion that fast track or emergency arbitration option is also available. Then the next topic is about technology, IP, and media contracts. In technology, IP, and media, see, confidentiality is relevant for all across the board. All contracts must be considered from confidentiality perspective. But in technology contracts, source code and other IP matters must be given due importance. Singapore and London, they are generally selected as the seat or forum for arbitrations arising out of entertainment, media, and IT. See, the next is shipping, maritime, and commodities. These contracts, the arbitration hubs are London and Singapore and Hong Kong. See, if the contract is for commodities, GAFTA provisions must be incorporated. If the contract is for oil and seeds and fats, then PHOSPHA provisions must be considered. So the objective is to impress upon you all that these are not the contracts which can be written once and used forever. Drafting arbitration clauses in international contracts, the boilerplate approach is at times risky. Poorly worded clauses, we just heard at the beginning that what is the effect and consequence of a poorly worded arbitration agreement. It raises jurisdictional fights, delay in enforcement, and even such clauses may be rendered as unenforceable. Now, before we discuss about the key considerations relating to drafting of an arbitration agreement, I strongly recommend to refer to the rules on arbitration and mediation, ICC rules. ICC rules and provide for extensive guidance for drafting of the arbitration clause. Article 12, 18, 11 are very important from the seat governing law jurisdiction perspective. Article 7 to 10, they deal with multi-party and multi-contract situations. It is advisable to prefer institutional arbitration over ad hoc arbitration. Seat of arbitration is a very important consideration, and the seat of arbitration should not be misunderstood or confused with venue of arbitration. We should avoid using the word venue, and the seat of arbitration must be used. The safe seats, I think we heard one of the panelists talking about the safe seats. London, Paris, Singapore, Hong Kong, Geneva, New York, and Stockholm. These are considered as, worldwide, they are considered as the safe seats. Avoid ambiguity, and the test of arbitration the seat of arbitration must be specifically defined as seat of arbitration and not venue. Okay, then the next important aspect is to properly define the number of arbitrators, the method of appointment, how the arbitrator will be appointed, qualifications, the technical expertise, language of the arbitration, and the scope of arbitration. The broad wording, the scope is very important because the broad wording will incorporate all sorts of disputes arising out of a particular contract. Confidentiality, many institutions like ICC, SIAC, LCIA impose confidentiality. It is an important provision that must be captured considering the nature of a document. The most important aspect is to carve out what is non-arbitrable matter, which are the non-arbitrable matters in the given set of facts and circumstances. All those matters which are not arbitrable, either because of the peculiar unique nature of the contract or because of the local laws, such provisions, such matters must be excluded. Now, to conclude, the golden tips to draft a suitable arbitration clause is to always include institution in place of ad hoc arbitration, to provide for suitable rules, the seat, governing law, number of arbitrators, language, and finality. Test your clause for clarity, completeness, enforceability in law, especially under the New York Convention, because under New York Convention, if the agreement is not valid, the award may not be enforceable. So therefore, it is necessary that the clause before the contract is executed is tested for the legality. Avoid creative drafting. Let it be a simple provision. Let us not be very creative in drafting unless necessary. I hope all the answer covers all aspects. Thank you, ICC. Thank you, ICC Sri Lanka.
Thank you very much, Mr. Majmudar, for that very wholesome answer and for covering a wide range of aspects as well, industries as well. My next question goes out to another eminent panelist joining us online, Mr. Rajendra Navaratnam. Mr. Navaratnam, do we have you?
Yes.
All right.
Can you hear?
Yes. My next question to you is that when drafting a dispute resolution clause referring disputes to ICC arbitration, what practical considerations should parties keep in mind to ensure that these clauses align with the ICC rules and therefore avoiding enforceability issues?
Thank you for that question. Before I give my answer, let me express my gratitude for being given the privilege of speaking at your conference and with such a distinguished panel. And in particular, I was sitting in the ICC International Court of Arbitration with Dr. Harash Cabral, who is also on this panel. And I had the privilege of him gifting me with his textbook, which I found very useful, especially when I was teaching a Chartered Institute of Arbitration course as an introduction to international arbitration in Sri Lanka a couple of years ago. So thank you, Dr. Cabral, and thank you for ICC. Now, I have prepared a few slides. I hope I can get them up. Just give me a moment. Now, much has been said by the previous speakers, and I hope I'm not going to be repetitive. But the approach that I'm going to take is really bring it down to basics. And the starting point, as Mr. Majumdar said earlier, is to keep it simple. And in this case, there could be no better starting point than the model clause, which is in the ICC rules. This is the ICC's recommended clause, all disputes arising out of or in connection with the present contract. That is the widest possible formulation you can have, and it will probably capture every possible dispute that is likely to arise. Start with that. It is clear, tested, and enforceable worldwide, and only tailor. Don't be creative, as Mr. Majmudar said. Keep it simple. Only put in what is necessary. Now, I'm going to have to come back to the seat, although many of the previous speakers have spoken about the seat. But the seat of arbitration is very, very important. And I would say that the seat of arbitration, as has been mentioned before, determines the lex arbitrae, or the law of the arbitration, the procedural law that applies, and most importantly, the court supervision. If you specify a seat that is not in an arbitration-friendly jurisdiction, you are likely to get a lot of court interference, and that you don't want. So you have to choose a seat that's reliable, which got reliable courts, which are supportive of arbitration. Not all courts are supportive of arbitration. Many courts, especially in our region, are a little bit suspicious of arbitration and don't want to give away what they think is their right to determine disputes. So you would find a lot of problems if you are not seated in an arbitration-friendly jurisdiction. Now, there is a juridical fiction between that. The seat of arbitration could be, say, for example, you could specify the seat of arbitration as being Singapore, for instance. So you take advantage of the Singapore courts, the laws or procedures that apply to arbitration from Singapore. That's very helpful. But you might find that you want to sit somewhere more convenient. You might want to sit in Sri Lanka. You might want to sit in Kuala Lumpur, somewhere where costs are lower, but you have all the advantages of the juridical seat of Singapore. Now, the other thing, which is a very important practical consideration as well, especially when you are dealing with an international contract where parties come from a different part of the world. Let's say you have a Japanese contractor that's coming to do work in Sri Lanka, an infrastructure project perhaps. Now, that Japanese contractor will be a bit reluctant to have its arbitration seated in Sri Lanka, and the Sri Lankan party may be reluctant to have its arbitration seated in Japan or in Tokyo. So what normally happens is the parties would choose a neutral location, and as a matter of convenience, somewhere that's geographically in between. Now, again, I have to say that Singapore has a great advantage in that example I gave. But let's not forget Kuala Lumpur as well, because Kuala Lumpur is equally geographically blessed. In between the major trade flows between India, Sri Lanka, Middle East, and Japan, East Asia, Korea, and so there is an advantage for choosing those as being, if not the seat, at least the place where you would want to, or the venue where you would want to conduct your arbitration. Now, as has been mentioned before, the core elements, you've got to decide on the cost, on the number of arbitrators. Now, obviously, a single arbitrator is cheaper than 1/3 the cost of 3 arbitrators. But the advantage of 3 arbitrators, you get, in theory at least, a more reliable result, because one arbitrator may go off on a frolic of his own, but 3 arbitrators less likely so. I say that with a caveat because I've had experience where there may be one dominant arbitrator in a panel of 3, and he drives the whole direction of that arbitration. So you have to choose carefully and wisely. And also, you could have a combination of expertise on the tribunal. Let's say you have a specialized, for example, contract involving, say, data centers. You might want to get someone who has one of the arbitrators has expertise in this area. You want have one arbitrator who has expertise in, say, construction, and you might have the chair who being a legally trained arbitrator who is familiar with procedure. So you would have the best of all worlds in that situation. So that's something it's nice to have. Doesn't always happen because parties, when they nominate the arbitrators, always want to nominate who they wish. But if you have lawyers who are knowledgeable, who are representing both parties, this is possible. It has been mentioned before, it's important to choose the language of the arbitration to avoid future disputes. And the governing law as well. It's important to choose the governing laws. It may be different from the seat. It's distinct from the procedural law or the lex arbitrae. The governing law is the law that governs the interpretation of the contract and how the implications of the contractual provisions. Now, we were talking about multi-party and multi-contract arbitrations, because sometimes you might have a multi-party contract, many parties in that contract, and maybe only two of them might initiate an arbitration. In that situation, you might want to join the other parties or some of the other parties in the arbitration. And the ICC rules here, Article 7, allow for it. Sometimes you might have two different contracts which involve the same subject matter or substantially overlap in terms of the subject matter. In that case, you might want to have a consolidation of these two arbitrations, and the ICC rules again provide for that in Article 10, but the caveat is consolidation only works if the clauses are compatible. So for example, if you have a main contract and a subcontract in a construction situation, you could have an ICC arbitration clause in the main contract, an ICC arbitration clause in the subcontract, and in that sort of situation, you can approach the ICC to consolidate the arbitrations. And you don't have to do any fancy drafting to achieve that objective. And you need to align these across all the project documents. Now, this is interesting because some of the previous speakers have actually alluded to some of them. Cardinal rule, keep it simple. And I think Justice Rajwa has actually mentioned pathological clauses. Now, the locus classicus of pathological clauses is the Singapore case of Insigma versus Alstom, where basically the agreement to arbitrate was supposed to be, the institution administering the arbitration was specified to be SIAC, Singapore International Arbitration Center, but it was supposed to arbitrate this or administer this arbitration in accordance with ICC rules. So you see there were two different institutions in the same clause. Now on the face of it, it's unworkable. But in the end, it went up on appeal to the Singapore Court of Appeal. And the Singapore Court of Appeal held in this particular circumstance, because SIAC had agreed to arbitrate according to ICC rules and actually identified equivalent officials within or equivalent bodies within within SIAC, which would carry out the functions of the bodies within the ICC. For example, the Secretary General of ICC was equated to the Registrar of SIAC and so on. So there were three different bodies. And so the Court of Appeal said in this particular situation, it was workable, and the SIAC was prepared to arbitrate it. And as one of the previous speakers said, there's always a presumption that parties have intended to go to arbitration. So the courts will try to save an arbitration clause. But here again, I will want to make this point, that if you get your arbitration clause drafting in an ambiguous way or in a pathological way, and if you have to go to court, it's going to derail the arbitration. It's going to cost you a lot of time and money before you can actually get to arbitrate the substantive disputes. So it's not enough to say the courts will ultimately rescue this this clause. Even in the Insigma case, it went all the way up to the Court of Appeal in Singapore in order to resolve the preliminary point as to whether the arbitration tribunal had jurisdiction or whether the clause would fail because there was an incompatibility within it. Then there's another one, which in fact this particular case in 2007, I was counsel in this case. It's a Malaysian case called Innotech Asia Pacific and Innotech GmbH. And there was a reference in that arbitration clause to a non-existent body. It was called SIHK, which turned out to be the Chamber of Commerce of Westphalia in West Germany. But it also referred to another body in Sweden. We failed to persuade our courts that this arbitration clause should fail for uncertainty. And they, again, I think correctly came to the decision that there was an intention to arbitrate. So they will give effect to the arbitration agreement as best they can. And also, sometimes you have the other classic failure of arbitration clauses is parties say they would refer their disputes to arbitration, but in the same breath, either in the same clause or in another clause, they would say the courts of a particular country would have exclusive jurisdiction. So what does that mean? So the consensus of opinion is parties intend to arbitrate their disputes in arbitration, but when you specify a court having exclusive jurisdiction, it will have exclusive jurisdiction to decide all the matters that support the arbitration. For example, determine whether there's jurisdiction or not, to grant specific relief, to grant preserving orders or to grant injunctions, anything to support the arbitration. So, and we have talked about confidentiality, but it must be expressed because there are some jurisdictions, like in ESO Australia, they said they drew a distinction between privacy and confidentiality. It was always thought that arbitrations were inherently, there was a obligation of confidentiality, but apparently not. In Australia, they say privacy. Many of the civil law jurisdictions in continental Europe also do not recognize confidentiality. And then similarly, emergency arbitrator, you might want to opt out. Expedited procedure, you might want to opt in for large value claims because expedited procedures are limited under most rules to low value claims. And multi-tier steps, I'm not going to touch on that. And so in conclusion, keep them simple, consistent, and precise. Model clause, starting point, seat arbitrator's language, bare minimum. Enforceability in 170 plus convention states. Just make sure that your award is not going to be a paper judgment or paper award. It must be enforceable because the country must be a member of the New York Convention. The seat must be a member, must be in the New York Convention member country. Thank you very much. I have been very honored to give this short presentation of what it's worth.
Thank you very much, Mr. Navaratnam, for that descriptive answer, and so sorry to have disturbed you mid-response. Ladies and gentlemen, that brings us to the end of panel discussion number 3. One more panel discussion to go, and I will hand it over to Dahara. I'd once again like to take this moment to thank our distinguished panelists for your valuable insights, contributions, and time, of course, and it's been a pleasure being your moderator. Thank you.
Yes, thank you very much to our distinguished panelists. I would like to invite the chairman and the board of the ICC, board members of the ICC Sri Lanka to present our distinguished panel members with a token of appreciation. Thank you. I would also like to invite Justice Tilakavardhana and Professor Vedikara to be present on stage while we distribute the tokens of appreciation. Thank you. Ladies and gentlemen, can I also remind you that if you have not dropped in your visiting card, please do send it across, as there will be a small raffle draw at the end of today's event. Thank you. Thank you very much to our distinguished panel members. And now, ladies and gentlemen, joining us online from Singapore, international mediator and arbitrator and member of the Dispute Board, Singapore, let us warmly welcome Mr. Anil Changaroth.
I know it's the end of the day. Thank you so very much for being patient and being with us throughout the process. We finally come down to the second half of this conference. The conference is Arbitration and Mediation Conference. We've just now got down to mediation. But I must say that several of the key speakers in the morning session throughout the day have alluded to a couple of points. One, appropriate dispute resolution, right? The use of the word appropriate is something that I've been using for the last 15 years, and it's on my website as well. I've moved away from it being alternate dispute resolution to what's most appropriate, right? That's one. Two, the panelists and keynote speakers also alluded to the fact that mediation is an approach that we must consider. So I'm going to take hopefully slightly less than 10 minutes or so going through my slides, discussing how the ICC mediation is of relevance and is of use in the construction industry. And I also have a couple of slides dealing with the issue of environmental, social, and governance. I know one of the speakers this morning also spoke about that. And it's a really, really important area of the law that's coming up. And I think a lot of you must get into it, right? So with that, let me just move down. Right, so the construction industry is among the most complex globally, involving governments, financiers, contractors, designers, consultants, and so on. So it's a complex exercise involving multiple parties and a whole lot of documentation. So if you think about a construction dispute and wanting to try and resolve the construction dispute, it is humongous. And the first thing that comes to mind is the fact that it's going to be so very costly for you to take it to court or to take it to arbitration, because you've got a whole set of documentation, a whole set of different viewpoints and parties coming from all angles. And to add to that, today, disputes are not just about contracts and money. They're increasingly involving environmental, social, and governance obligations, right? And what I'm going to showcase to you is that the ICC offers rules and frameworks that help manage all of this to a large extent, all right? Now, basically, what's conflict arising from construction, what the ICC rules provide, and the role in ICC's role in dispute resolution, some key points about the mediation rules and how you integrate that to ESG issues, and why should mediation and what are the key points going on, all right? Now, starting point on construction matters is this. Why? Why is it so complex? Because you've got a whole lot of technical issues that could arise, design errors, unforeseen site conditions, scopes, creep in, uncertainty and disputes, financial pressures, rising costs, delay payments, cash flow problems, cultural and legal diversity. Global projects face different laws, practices, and expectations from different countries. And you have this added problem of ESG, environmental, social, and governance. Environmental can be anything that deals with sustainability and how your products and your equipment that you use are sustainable. Social can involve the employer, employee, contractor, subcontractor, stakeholder arrangements, and governance obligations can be your shareholder agreements and your internal policies in running the company and the operations, all right? Now, the impact of unmanaged disputes, if conflicts are managed early, they escalate into if are not managed early, they can escalate into a costly affair, into delays, arbitration, litigation. Throughout the day, you had speakers speak, a whole lot about the problems of taking matters to court and taking matters to arbitration and the complexities that could arise, right? The stakes are high, the project timelines can slip, budgets balloon, and relationships can suffer, right? When you take a look at ESG angle, like I mentioned to you, the environmental angle includes climate commitments, green compliance, carbon footprint. The social angle can go beyond just employer, employee, contractor, subcontractor, but also look at the community impact, labor rights, safety concerns, and governance can look at the transparency, corruption, and procurement methods. And I'll mention a particular case about this as well. And ESG issues are now central to construction disputes, right? So you have to understand that this is really quite critical. And then you take a step back and you wonder to yourself, oh my God, how am I going to get this resolved? Am I going to go into arbitration? Am I going to go into court? And is all of this going to come out, right? Answer, very simple, right? Let me just, before I answer that, let me just take a couple of quick pointers on environmental disputes. The ICC rules allow parties to design a process tailored to the dispute critical environmental issues and how to handle it. And what you can do is that you might appoint a mediator who's got some expertise in this field that can handle these things. And they might involve some, sensitive data, community concerns and all that. So you want this to be held in confidence. You want environmental issues not to be blown out of proportion, not to be put into the public domain with court proceedings, but in a closed door environment. Social impact, ICC mediators consider not only technical and financial issues, but also community, labor, and cultural issues. So a mediator can do all of that as well. Okay, so it's a holistic approach about how you resolve these issues. And when you talk about governance, the ICC rules require independence, neutrality, and ethical practice. This has been alluded to throughout the day. This ensures that the dispute resolution process are transparent and trustworthy, aligned with modern governance expectations. So you have all of these frameworks that can deal with ESG issues. Why take it to court? Why take it to arbitration, right? When you can actually just take it to mediation. And I hope to be able to discuss a little bit about costing and all that, not in my presentation, but probably in the panel discussion. Now, when you talk about integrating ESG into ICC dispute resolution, I said again, ESG is no longer just optional. ICC mediation and dispute resolution help embed issues that arise from ESG and put it all together, and you can have that resolved through the ICC process. Now, when you talk about ICC, again, many of the speakers this morning spoke about it, but I just want to just quickly sum up, right? It's got an array of dispute resolution services, and that's why ICC is here in Sri Lanka canvassing, right? Before conflicts emerge, when the conflicts have emerged but have not arbitrated upon, or if arbitration has commenced. So in all of these three categories, you can take your dispute to be resolved through the ICC process, right? Now, the ICC's guide on effective conflict management has got different aspects. It's got mediation, it's got expert process, it's got dispute board, and documents only, and arbitration, of course, right? So you have all of this array. And this is what you mean by appropriate dispute resolution, right? Meaning that you can adopt what you think is the most appropriate method of dispute resolution without having to just say, oh no, I have to go to litigation. Oh no, I have to go to arbitration. It's not necessary and it doesn't work that way, all right? Now, the ICC's role in dispute resolution, they have the mediation rules, they have arbitration rules, and they have dispute boards. And all of these are mechanisms that you can turn to try and resolve your disputes without incurring too much time and too much cost, all right? Now, why mediate then, right? It's a rights base as opposed to interest, right? Okay, I mean, there's this issue about rights and interest. You come in there with saying that I have a right to this, but at the end of the day, you leave looking at what is in the best interest of the parties. That's what happens. So parties come to a mediation with their positions, but they go away with looking at the bigger picture and what's of interest. It protects the relationship, and it really is an efficient process. One quick point, an example, about 8 years ago, I was in Sri Lanka. A developer asked me that he was going to go into a problem and asked me what I suggest. And I suggested mediation. It was new. He didn't know what it was about. And I told him how much it's going to cost, and his eyes lit up in excitement. 2 years later, when I saw him again, I said, what's been happening? He says, we are in arbitration. 3 years later, when I saw him again, I asked him, how's it going? He was still in arbitration. So the point of the matter is this: if you take it to mediation, you could probably solve the matter in a day or in a week at the most, right? In the most, there are mediation matters that I deal with takes not more than a day, right? I haven't had to deal with it more than that, and I've dealt with multi claims, to 20 million, $30 million claims, and have resolved that in a mediation within a day. All right. Now, the ICC rules, apologies for that. The ICC rules, mediation rules, deals with these things: voluntary and confidential, flexibility, flexibility, right? Neutral expertise, right? And cost and efficiency. So it deals with all of these things, okay? So that's the advantage of our ICC rules, right? Now, basically the mediation builds trust, helps you build trust because you are sitting down there trying to resolve a matter without looking through the whole documentation and a whole array of things. You just get straight to the point about looking at what's the party's interest at the end of the day and whether or not these two parties can come to a settlement that's satisfactory to them, right? Now, I just wanted to highlight two cases, right? And this hotel case I thought was very interesting. No pun intended in the name of the hotel, but it was a dispute that arose out of contractual agreements entered into between the parties in 2012 regarding the construction of chalets and beachfront, and over certification of interim payments claims, right? Now, the court on the 31st of May last year concluded that the defendant failed to remit payment on this payment certification, and there was issues of additional costs, counterclaims by the plaintiff, and all of that, right? Don't forget, a 2012 contract that was entered into, claims that were raised a couple of years later, a decision of the court on the 31st of May 2024. Point of the matter is this: if you take it to mediation, parties could have negotiated, maybe adjusting or agreeing the payment schedule, agreeing to some overhead, remobilization fees and mutual concession on interest, settling the mechanisms. They get the choice to decide on all of these things that are beneficial to the parties at the end of the day, right? So this is one example. Another case, there's this judicial review and procurement dispute filed by this construction company. It was a petition contesting the decision of the Road Development Authority and associated companies rejecting their bids of a procurement deal, right? In this particular case, right, the court held that the procurement process adhered to legal framework and made several other decisions. Now, I'm saying that if you had taken this to mediation, what you could have brought in a neutral person to review the evaluation process, suggest adjustments to the bid, because the mediator can make those suggestions and have parties consider whether they'd like to do that. Perhaps a monetary settlement or rebid, a mediated settlement that could include commitment from the RDA for more transparent procedure, compensation, and so on. So you see, mediation gets you to do these kind of things, right? Thinking outside of the box and working outside the box, right? So the key takeaways I want to say is this: construction is a high risk and shaped by ESG obligations. Conflicts are inevitable, but escalation is not. ICC mediation and dispute resolution rules offer trusted, flexible framework. And the mediation enables a creative, sustainable, and a relationship-preserving solution, right? And in closing, I'd just like to say this: in today's construction world, success is not just about completing the project, it's about completing them sustainably, fairly, and without leaving unresolved conflict behind. And the ICC mediation is the bridge to get you to that point. Thank you. I'm done.
Thank you very much, Mr. Anil Changaroth. Ladies and gentlemen, moving on to one final round of panel discussions. That is your last and final panel discussion for the day. To do the honors, it is my pleasure to warmly invite our moderator, Ms. Dahara Vijayaratna, to guide this session along with our distinguished panelists joining us physically today. Ladies and gentlemen, please recognize an eminent panel consisting of the Additional Solicitor General and President's Counsel, Mr. Sumati Dharmawardana, President's Counsel, Mr. Udita Igalheva, President's Counsel, Mr. Shanaka Ranasinghe, President's Counsel, Mr. Jeffrey Algaratnam, President's Counsel, Mr. Neil Unambua, Australian legal practitioner and founder and principal lawyer of Fairfields Lawyers Australia, Mr. Don Sasantha Katugampala, and legal officer and board secretary of the Construction Development Authority, Ms. Chandi Dialwis. Ladies and gentlemen, we are also delighted to have Mr. Anil Changaroth, join with us online today. Let us all give them a round of applause as they take the stage for one final engaging and insightful discussion.
Thank you, and a warm welcome to our distinguished panelists of the final panel discussion for today on the effectiveness of resolving construction disputes through mediation. Mediation has emerged as a valuable alternative to litigation and arbitration, offering a less adversarial, more cost-effective, and relationship-preserving method of resolving construction disputes. Despite its advantages, however, mediation remains underutilized due to factors such as limited awareness and concerns over enforceability. This panel will explore its effectiveness in the construction sector by examining timing, mediator expertise, enforceability of settlements, and comparative benefits over other mechanisms. Before we begin, just a kind reminder to our panelists that we will have the timer running at 4 minutes, and we'll try to keep it strictly to 4 minutes, although I do understand it is very difficult to cover such a diverse topic in that given time. But thank you, we really do appreciate your contribution here today. My first question would actually go to Mr. Anil Changaroth. He's online with us. Sir, what do you think the main barriers are which prevent parties in the construction industry from choosing mediation, and how can they be overcome?
And I'll explain why. In Singapore, most matters go to mediation, right? In the state court where the claims are up to 250,000, 80% of the matters go to mediation first, right? And so in other, and you find a lot of construction matters parties also wanting to go to mediation at the end of the day, right? So whereas in other countries, the concern is this, the point that you highlighted on enforceability, right? They're not sure whether or not mediated matters can be enforced. Now, my simple explanation of that is very fast, right? If you have a construction dispute, you have this much documentation at the start, right? If you come to mediation and you settle the matter at mediation, you sign an agreement, and it's just a one-page document. Now, if there's a breach or a default or on that mediated settlement, parties only have to rely on that one document and make a claim, right? So it'll be a breach of contract and you sue on that contract, right? So all of the rest of the documentation are no longer relevant. So the point of the matter is very simple. The issue of enforceability is not an issue anymore in mediation. And coupled with the fact that we have now the Singapore Convention on Mediation, right, that makes the enforcement of international mediated settlement like the New York Convention for Arbitration, it gives it another strengthening base for it, right? So and as I alluded to in my discussion just now, if you look at it, would you rather have a voluminous set of documentation put before the court and spend 3 to 5 weeks in front of a court hearing or in arbitration for weeks on end? Or would you rather come to a mediation where parties look at the end of the day what the interest of each party is and then try and come to a settlement that they can think out of the box and work out of the box? So it's a very simple thing. And just one last point is that you started off by saying that mediation is a good alternative to other. It is not a good alternative. It is one of the most appropriate dispute resolution mechanisms that are available, and a lot of people need to do that. And last point, sorry, I do apologize. Last point is this. Parties need to be educated on mediation. So getting people onto the mediation platform involves a whole lot of education. Right? I train in that. I've developed programs. In fact, one of the first mediation programs that was conducted in 2017 or 2018 in Sri Lanka was formulated by me, working with the US aid, and that's it. So that's what I wanted to say quickly. Thank you.
Thank you. Thank you very much, sir, first of all, for the valuable contribution that you gave to this conference and for sharing your perspectives and insights with us. I would now like to raise a question to Mr. Sumathi Dharmavardhana. Given the current context, sir, of mediation in Sri Lanka, do you consider it to have the potential to develop into a viable and widely accepted method of dispute resolution?
His Lordship Justice Nawaz, ladies and gentlemen, I have been given a question and time is very limited. As you all are aware, Sri Lanka underwent through a very turbulent period with the COVID-19 breakdown and the political unrest. With the IMF bail package coming in, the construction industry has picked up, but not to the full force. Therefore, there are a number of pending disputes. This morning, Justice Kodaguda spoke about how we can promote mediation in Sri Lanka by educating the legal practitioners. I think that's a very vital point which I made a note. Having said that, yesterday I made inquiries, my lord, from the Registrar of the Commercial High Court. There are 4,179 arbitration-related cases are pending before the Commercial High Court. So that's a fairly large number. It's appropriate that the ICC had taken the initiative to promote mediation as an alternative for arbitration, because with 4,000 odd cases pending in the Commercial High Court, it speaks volumes that the matter has not come to an end. The litigants have not got the relief. On this context, the government has taken a very bold initiative to bring the mediation bill, and that's presented before the Parliament and already gazetted, the Mediation, Civil and Commercial Disputes Bill, which was scheduled for taken up for second reading. And Anil, our good friend from Singapore, mentioned how Singapore has moved forward in his last presentation, and he mentioned about the ICC rules, so which I will not go into that, but there is a very pertinent point in the ICC rules where they given a provision in the ICC rules to sign an agreement after the mediation process is over with the mediator countersigning the agreement. When we look at the Sri Lankan law, in the draft bill, it gives provision to submit the agreement. I'm referring to the draft bill. In section 18.1, it refers where the parties have reached an agreement on the terms of settlement, mediator shall, after being satisfied that the parties clearly understand the terms of settlement and obligations arising therefrom, ensure the terms of settlement are set out in writing in a settlement agreement. Then the settlement agreement has a binding effect in terms of the draft bill, which is before the Parliament, which has gone through a special determination before the Supreme Court. And I trust this will move forward, which will have a procedure, will be very easy to cut down the time, because the agreement, settlement agreement, is enforceable. Like in the Arbitration Act, they have brought in one of the grounds to challenge it is the public policy. In addition to parties are not having required qualifications to enter into the agreement and so on. In order to economize the time allocated to me, in nutshell, I will put it, the ICC has taken a very good initiative to educate the public and the practitioners about mediation. Government of Sri Lanka has taken a step forward to legalize the mediation process, and if the Parliament use its own wisdom and pass it, I am sure we should be able to make use of it to have a speedy dispute resolution mechanism. My time is up. Over to you.
Thank you. Thank you very much, sir, for your answer. I would like to now direct my next question to Mr. Udita Egalaheva. How does mediation in construction disputes compare with arbitration or litigation? Do you think it is an effective means?
Well, thank you, Tara, for that question. I think it should be an effective method of resolving disputes. As my good friend
said that there are so many cases pending in the Commercial High Court, pending enforcement or setting aside. But I see a major problem in introducing mediation to Sri Lanka because we are used to a adversarial system, claims and fight. So to settle and enter into a settlement agreement, you have to have a different mindset. And also, it's easy to determine or decide a dispute as adjudicators, arbitrators, or judges. But to be a mediator, you need a special skill and special training. So that is an art. So that has to be cultivated, and that culture has to be brought in from adversarial to mediation. And those are the main problems I find it for enforcement. And a few years ago, ICLP took a very good step in training technical personnel like engineers, various other professionals as arbitrators. I think we have to have a method of training. Second thing is, in Sri Lanka, the construction industry, when you take construction industry, 70%, because I'm involved in many disputes in arbitration, 70% of the arbitrations in construction industry are related to state or state institutions. And there is a culture right now that state is not prepared to settle. The arbitrators try to do this because mainly nobody wants to take a decision with this political culture. Nobody wants to say, okay, I agree to this, right? So as a result, nothing is settled, things are being dragged on. And to start with, there are DAB decisions. DAB is a Dispute Adjudication Board, appointed by both parties or most of the time appointed by the employer, but not honored. That is being challenged by given by their own engineers. So this culture has to change if this is to be successful. Thank you.
Thank you very much, sir. Thank you for addressing the culture issue. I think the rigid mindset that a lot of people have, even in the legal profession, is what keeps us from utilizing mediation even to address disputes or even to address construction disputes. So thank you for sharing those valuable insights. My next question goes to Mr. Neil Unambua. What incentives or policy reforms do you believe could encourage more widespread use of mediation in terms of construction disputes?
Yes. Now, with regard to this particular question that you have asked, considering the Singaporean Mediation Act, which was passed in 2017, in that environment only I will have to answer. For the reason that we are yet to see our bill in operation. And the ability and the area that we could develop on in the future. So my first answer to that question is, the financial incentives, I have listed them so that I will not take much time and also I'll be accurate with regard to my answer. So the first item number one is the financial incentives, targeted and measurable. For an instance, SME subsidy or voucher schemes to be provided. Then the number two is with regard to tax relief or reduced fees to be considered. Then the performance bond adjustments. Going to the next item, it is the procedural cost incentives that the country will have to consider. Pertaining to cost uplift for refusal. That is, if a party refuses to enter into or voluntarily agree to go for a mediation, then the kind of a penalty. Then the fast track enforcement window to be introduced. Number 3 is reputation and market incentives. It goes on, then the judicial incentives. Finally, the governmental incentives. Now, these are aspects to be considered and introduced into the act itself. Now, one particular situation that took place way back in 1980s and 1990s in England was when Shapiro, he was a US media expert. He went to UK, and when he went to United Kingdom, he found a particular situation there with regard to mediation. Now, I'll read that part of it. David Shapiro, the leading US mediator who moved to the UK in mid-1990s, had this observation. Very interesting. One thing that was clear to me when I got here was that as a purely voluntary process, mediation was a dead duck. So judicial intervention was needed to provide the catalyst for further substantial growth in the field. Now, in this scenario, there was a similar situation where Lord Justice Wolf, in the case of Cowell versus Plymouth City Council, he stated something very interesting. May I read that part of it? The importance of this appeal is that it illustrates that even in disputes between public authorities and the members of the public for whom they are responsible, insufficient attention is paid to the paramount importance of avoiding litigation whenever this is possible. The courts should make appropriate use of their ample powers under the civil procedure rules in England, which is similar to our civil procedure code, to ensure that parties try to resolve the dispute with the minimum involvement of the courts. Now, that is very interesting. Thereafter, the United Kingdom amended their civil procedure code, facilitating mediation to be taken into consideration. Now, in this scenario, since my 4 minutes are going to be up, I'll try to my view is that with regard to the reforms, that the question with regard to the reforms,
yes,
to encourage mediation in respect of construction disputes in Sri Lanka, I would suggest that the civil procedure code be amended. Also, the Primary Courts Procedure Act, Urban Development Authority Act, the Municipal Council Ordinance, Urban Council Ordinance, and the Pradeshya Sabha Acts, Electricity Act, and Sri Lanka Sustainable Energy Authority Act. It goes on. So these amendments, if are brought, incorporating the feasibility of having mediation, I believe the cases that gets accumulated in courts, like the 4,000 odd arbitration cases, spending such a lot of time, problems with regard to interpretation, problems with regard to seat, all those things could be resolved with the adoption and with the adherence to mediation systems, which would take only a day or two or a few days. Thank you.
Thank you. Thank you very much, sir, for that comprehensive answer and for sharing such valuable insights with us and for proposing such incentives and the policy reforms. Thank you, sir. My next question goes to Mr. Jeffrey Algaratnam. Sir, in cases where mediation succeeds, What mechanisms ensure compliance with mediated settlement agreements in the construction sector?
It goes back to the basic question, why do you go to mediation? Because it's intended to provide a very informal, friendly atmosphere in which you arrive at a settlement in favor of both parties. So what, as in most laws, what we really expect, we can have the best of laws, but we have to have good people who to administer them and for success. So basically, you go in with an idea of looking at the interests of both parties, the compromise, mediated settlement. So the intention and the wish is there is a moral binding obligation to comply. And of course, apart from legal aspects to enforce, in the event of a person dishonoring his word of honor by signing a mediation agreement, what do we do, where do we go? So that is whether there could be industry pressure in the construction industry where you get black marked and things like that, because you signed an agreement, you said. Because I think we have Justice Nawaz here who will really agree that half the time you win a case, you take more time to enforce it, the judgment, right? So it should not be that for mediation. But as Mr. Sumati Dharmawardana just explained, there is a fairly good bill before Parliament. And if that is enacted, we hope that parties to a mediation agreement will be morally obliged, will be good people, and there may be other types of pressure to ensure they honor it. But in the event of a dishonor, whether that law, which is similar to the arbitration law that we have at the moment, will ensure an enforcement of the order or the mediation agreement, which really it's not an order. It's an agreement negotiated by the party. The mediator is only a facilitator. He's not a judge. And as Anil said, it cuts through all this paperwork, it cuts through everything, it just goes down to a one-page document or a two-page document. So that if this law is passed, it's going to be very valuable, and I hope it will be passed. Then you go into court in the event, I hope in the unlikely event of someone not honoring his mediation agreement. Then you enforce it, and it can only be, say, challenged on very limited grounds as provided there, like, for example, conflict of interest of the arbitrator or an incapacity, the mediator, or an incapacity of one of the parties. There are various heads given there. And that should end it. Of course, I hope the same culture won't prevail in the court system where when we have arbitration agreements and we try to enforce it, it takes another 2 years, right? So that whether the culture is important. How the courts think, how the persons to the mediation agreement, even to work a good law, there can be delays. Right? So that is important, where the court should be told, okay, the moment it comes in, no nonsense, you just enforce it, unless they can show very good grounds. Here, if you look at arbitration, what happens is, the judge issues notice to the other side, to come and show cause as to why I should not enforce it. Why doesn't he straight away say, I'm enforcing it against you, unless you are able to show me good cause. And then if he fails, he goes up to the Supreme Court, and it's another, I suppose with the backlog in the Supreme Court, as Justice Nawaz would say, it may take about 9 months to support the order. Right? So these are the practical aspects I'm thinking of. Of course, if you have two parties who are Sri Lankans, it's easy, you can enforce. But if you have a foreigner, then you have the problem where the Singapore Convention or whatever the ICC rules are, then you have a decree, but you have to go for the assets. So it will have to be where that person is. If it's the Singapore Convention, it might be easier to enforce it. But otherwise, you'll have to depend on the reciprocal enforcement of judgments, which we have just passed. So you have a judgment, a decree here, you can enforce it in New York, or Britain, or UK. So those are the aspects. But if this law is not passed, we might have to enforce it as a mere contract in an ordinary court of law. So those are the things I see forward for this, with the possible areas of ambiguity, but the main thing is the culture.
Thank you. Thank you very much, sir, for that answer. I would now like to raise my next question to Mr. Shanaka Ranasinghe. Sir, to what extent does the success of mediation in relation to construction disputes depend on the technical expertise of a mediator?
Thank you, Tara. Now, why do we come for mediation? The person wants a speedy resolution in a very friendly atmosphere. Now, when we Before mediation came in, what were the other resources? You either go to court or go for arbitration. Now, has the judges got the expertise, technical expertise? The answer is no. Very few, if at all. You'll take the case of arbitrator, it's similar. A role of a mediator is to, away from court, away from arbitrator, the parties to, without disturbing their relationship, come into a resolution, one sheet resolution within a very short period of time. Now, if you look at that, so therefore, my personal opinion is that your expertise, technical expertise is not a must for a mediator. Certainly, if he has some expertise, yes, that will give him the added advantage in resolving and pursuing the parties. Look at this, your question, look at the expert opinion of this side. Now, but that's also, it's not necessary. You look at the ICC guidelines. ICC can provide technical expertise report. So before the parties sit down and sign the mediation, and come to a resolution, you can call for a report. So it's not a must. A mediator role is to somehow convince, look at the dispute, co-dispute, and advise the parties to, in a friendly atmosphere, to come into a resolution. So at a friendly atmosphere, the mediator's technical expertise is not a must. It's not a must, but certainly it has the advantage. So, and a mediator's role, I would suggest, before, especially in the construction field, if there is a technical issue, the technical expertise report should be called so that you know what is the issue, and you can go through that report and advise the parties to come into a settlement or the resolution within the short period. I think that will be the answer of my...
Thank you. Thank you very much, sir. May I also extend this question to you, Ms. Chandi Diavis? How important do you think the technical expertise of a mediator is in a construction dispute?
Yeah. Thank you, Dara. As we know, mediation is a negotiated settlement, whereas in adjudication and arbitration, which is relevant to the construction industry, the independent third party gives the decision by which the parties to the contract is bound. In mediation, the mediator only facilitates the parties to come into a settlement. Then in that case, a special kind of skills are necessary for the mediator. In that aspect, the technical knowledge should not be a must. That is my answer. You need any further explanation?
Yes, if you could also highlight a little bit on the legislative framework of the mediation process for the construction industry in Sri Lanka, if you can just touch up on a few points on that also, that would be... Thank you.
Yes. Now, I represent the Construction Industry Development Authority, which is established under the Construction Industry Development Act number 33 of 2014. In the section 50 of the Act, we specifically say that the initial method of resolution of disputes in a construction agreement should be mediation. Then only, if you fail in mediation only, you can go to adjudication, then after that arbitration. Then as the apex body of construction industry, SIDA used to issue the standard bidding documents, which was actually prepared in 2007. way back in 2007, we have said the initial dispute resolution method is adjudication. Now, as per the revision of the SPDs, we have said the initial step should be mediation. And CEDA is taking steps to make awareness in the industry, and we are conducting sessions for the parties to come into settlement. And in that case, the mediators, actually what is currently happening is the industry experts are helping us as the mediators to conduct the sessions. That is practically happening. But as I said, that knowledge, that the technical knowledge should not be a must, because he's acting in a different role in the mediation. And also, if I mention some further points, two things would be very important when you come into settlement with a mediation. That is, when two parties are sending their representatives, they should be in a position to take decisions on behalf of contractor as well as the employer. So the organization which is sending the representatives should authorize them to take decisions, and as well to enter into agreements, the mediation agreement initially, and at the end of the process, the settlement agreements. Otherwise, when you go back to your organization, the decision or the settlement which the parties have entered into might not be recognized by the particular institution. That is there. And also, mostly, as one of our panelists also said, employer in a construction agreement is always, in most of the time, it's a government entity. Then, and the settlement agreement would also, in most of the cases, would be a payment. Would be a kind of payment. So the treasury might have to approve it, and the auditors have to agree with it. Then also the accountants of the company has to agree with it. So those parties have to be made aware of the process of mediation. That also have to be kept in mind when you enter into mediation.
Thank you. Thank you very much, Ms. De Alves, for sharing your perspectives and also through your experiences working for CEDA. Thank you. My final question goes to you, Mr. Susantha Katugampola. Taking into account your experience in the Australian legal practice, do you think mediation should be made mandatory in construction disputes before you proceed to arbitration or litigation?
The short answer is yes. And first, I would like to thank and extend my gratitude to the president of ICC, Shanil Fernando, and the board and the team members of ICC for giving me extending this opportunity to me. And I'm not a lawyer in Sri Lanka, although I'm of Sri Lankan origin. So I practice law in Australia. So I can only share that Australian experience. So the Australian experience is that every civil matter, in every civil matter, mediation is almost mandatory. So other than when you go to our legal system is sort of state-based. We have different states. I'm sure you're familiar with the Australian system to somewhat. So we have different states. The states got the district, equivalent district courts here. This is the county courts. And then we have the Supreme Court, which is the highest court in that state. And then you got the High Court, which is the highest court in Australia. And then the federal matters are contested heard in federal court. So when it comes to any civil matter other than criminal, everything has mediation. So I just need to endorse what Neil said before. I think he has brought the UK example. So with the mediation will give you the outcome. It brings the right outcome to the clients. But the way forward is, as lawyers, you need to initiate a very good application, file a very good application in the courts. That's your statement of claim. And then a very good defense. and then the court refers you to mandatory mediation. It happens in the county court and mostly in the Supreme Court in all commercial matters. And what is important for Sri Lanka is Sri Lanka's future requires the growth in the construction industry. Construction industry can bring the value to GDP in this country. So I hope that this country will move forward. That is our wish. And if we were to grow the construction industry, we need to bring international players to this country. We need to open this country. We need to have foreign investments coming into the country. So if you're bringing the foreign investors and the foreign players as contractors in construction industry, you need to give them absolute confidence that we have a very good and easy legal system. And I would say a legal system that can be accessible and cost-effective and efficient legal system. So mediation can play a very important role. And I've been coming here, although I'm out of this country for the last 35 years, coming here as a law student from Monash University and then as a lawyer for 3 decades. But this is a time that the litigation, the courts are all in the media. I have not seen this before. And I'm somewhat disturbed. So I see that Sri Lanka as a country, we should promote dispute resolution. So I think while we respect the courts, while we need the judiciary, and we need the judiciary, the system, to promote that mediation. And the good news we heard from the Sumati Dhammavardhana, PC, and he speaks from the government, AG department. So it is coming, which is a very good news. So in addition to the legislation, we are required to put resources, money, to have the mediators and the system in place. That's a very good system change for betterment of this country. Thank you.
Thank you. Thank you, sir. And thank you to our eminent panel here today. I really do wish we had the chance to carry out this conversation further, but unfortunately, due to time constraints, I'm compelled to end this panel discussion. Thank you very much once again to our distinguished panelists. Over to you, Dahami.
Thank you very much, Dahara, and thank you very much to our distinguished panelists for your presence and contribution. May I kindly request you all to please remain on stage to receive a token of appreciation. Can I kindly request you to please remain on stage? I'd like to invite the presentation party, the chairman of the ICC, and the ICC board. Thank you very much, ladies and gentlemen. One more thing before we wrap up for today. So it's time for our raffle draw. If you have dropped your visiting cards at the registration desk out front, you are in the running. One lucky winner will receive a 50% discount on either the certificate course in commercial mediation or the diploma in arbitration happening this October, courtesy of the ICC Sri Lanka Arbitration and Mediation Hearing Center. So half price and full education, I guess. All right, let's find out who the lucky winner is. And to do the honors, I'd like to call upon the ICC Sri Lanka Chairman, Mr. Shanil Fernando, and the ICC Sri Lanka Board. Mr. Fernando will be joined by Ms. Natasha and Ms. Hiranya, and let's find out who the lucky winner is. All right, so in case you did not hear that, if this particular individual who has won the prize is not present here today, the company representing the individual anyone from the company representing the individual can also make their way forward to the stage to receive the gift or the prize. All right, starting off with our first winner for the day, walking away with 50% off from these two educational diplomas in arbitration. The first is Senarath Bandara from Access Engineering PLC. Can we have a round of applause for Senarath Bandara from Access Engineering PLC? Do we have anyone else representing his company? Yeah, seeing as though he is not present here today, the company can, of course, nominate a person on his behalf. Our second winner for the day, Mr. Sisira Kumar Herath from People's Leasing. And a third winner for the day, Miss P.A.P. Vishwa Senarachi from Sri Lanka Telecom. Thank you, Mr. Fernando. To formally close the proceedings for today, I'd like to invite the Secretary of ICC Sri Lanka, Mr. Indika Rajapaksa, to please deliver the vote of thanks.
Good evening, ladies and gentlemen. Distinguished judges of the Supreme Court of Sri Lanka, esteemed President's Councils, distinguished speakers, panelists, ladies and gentlemen. As we conclude the fourth International ICC Arbitration and Mediation Conference today, it is my privilege and honor to extend our heartfelt gratitude to all those who have contributed to making the event resounding success. First of all, our distinguished international speakers. We express our sincere appreciations to our esteemed speakers who traveled from Singapore to be with us physically today, Mr. Tejas Chauhan, Mr. Dato Jute Beni, Mr. Samir Jain, Mr. Abhinav Bhushan. Your expertise and insights have enriched our understanding of international arbitration and mediation practices. Special thanks to Mr. Jasmine Reis, who traveled from Malaysia to share his valuable knowledge and prospectus with our gatherings. Secondly, our eminent panelists. We are deeply grateful to the Honorable Judges of Supreme Court of Sri Lanka, the distinguished President Councillors, and all other panelists who participate both physically and virtually. Your contribution have elevated the discourse and provided invaluable perspective on the evolving landscape of arbitration and mediation. Thirdly, our profound gratitude goes to Mr. Shanil Fernando, Chairman of ICC Sri Lanka, whose leadership and vision made this conference success. We also extend our appreciation to the entire organization, team and staff of ICC for their planning and execution of this conference. We acknowledge the Board of Directors of ICC Sri Lanka and the ICC Sri Lanka Arbitration Mediation Hearing Center for their continuous support and strategic guidelines. This conference would not be possible without our valuable partners and sponsors. Our platinum sponsor, Colombo Stock Exchange, supporting sponsors, Commercial Bank PLC, Asa Securities, Sampath Bank, People's Insurance PLC, Monaco Marine Private Limited, Hatton National Bank, DFCC Bank, and Pan Asia Bank. Our technology partners, OneSmartB, who provided the QR code solution that enhanced our digital presence. Event management support services provided by Mr. Ruwan Senanayaka and his dedicated technical staff, Job Enrich Private Limited, who handled the event management with exceptional professionalism and attention to details. We thank Ms. Dahami Fonseca, attorney at law, for her excellent work as the conference compere, ensuring smooth proceeding throughout the day. Our gratitude extends to the entire staff of Shangri-La Colombo as well. In our conclusion, the success of the 4th International ICC Arbitration and Mediation Conference stands as a testament to the collaborative effort of all stakeholders. The knowledge shared, connections made, and insight gained today will undoubtedly continue to the continual growth and development of arbitration and mediation practices in Sri Lanka. As we conclude today's proceedings, we carry forward the collective wisdom shared and look ahead to future opportunities for advancement in alternative dispute resolution mechanisms. Thank you all for your participation, support, and commitment to excellence in arbitration and mediation. Thank you.
Thank you very much, Mr. Rajapaksa. As we come to the close of this insightful and engaging day, I'd like to take a very small moment to extend a heartfelt thank you to everyone, our esteemed speakers, panelists, special invitees, sponsors, and of course our learned audience members who have joined us here today for your active participation and valuable time and contribution. A very special thank you also goes out to the ICC Sri Lanka Chairman and the Board of ICC and staff for their tireless efforts in organizing this conference today and making it a reality. Your hard work and dedication has truly paid off. This conference has reminded us of the power of collaboration, shared knowledge and thoughtful discussion in shaping important discussions and of course creating awareness. I know that both our speakers and participants present here today come from various industries with a plethora of knowledge and expertise. That has truly been a privilege to listen to you. I do hope that this event today was an opportunity for you to take away not only practical insights, but also a renewed sense of appreciation for dialogue, collaboration, and innovation in your work. Wishing you all safe travels and continued success in your respective professions and beyond. Thank you for being a part of the 4th ICC Arbitration and Mediation Conference. Thank you very much.